but it is still in violation, my lord.
It will be listed. Why it will not be listed without memo?
Well, yesterday they are blasting in the website, my lord.
No, that is all right, but without memo, it will not be listed within 3 days.
Yesterday we have filed a mood a contempt.
All at
petition.
21st. 21st.
My lord, the appellant is a bank, my lord. The learned single judge has allowed the writ petition against the bank, the appellant hearing, directing the bank to give back possession, my lord. However, the loan has still not been cleared. The respondents have already filed contempt before this court, my lord. It will be listed on the 29th.
Your for bank.
Please, my lord.
21st.
My lord, on the 29th, it will be listed. Please, my lord. Both are connected matters, my lord.
My lord, it's a labor matter, my lord. The appellant is erroneously terminated from the service, my lord. He is the only breadwinner of the family. It is an urgency matter, my lord. Please,
Appeal.
Huh.
Appeal or contempt?
appeal, my lord. He is terminated
For submitting them. Said within 1 week.
kindly, my lord. It's an urgency. He is the only breadwinner of that family. my lord.
Then we listed. See that it is listed. No, ma'am. It will be listed within 1 week. If it doesn't get listed within 1 week, mention again.
Not much.
Yes, ma'am. Anything? Yes, madam.
Your lordships, serial number 28 to 31, your lordship.
28.
28, 29, 30, 31, your lordship. 4 matters, your lordship. 28 to 31, your lordships. We have filed a rejoinder. The other side wanted to take time and she couldn't be there, so she asked me to mention, your lordships. We don't have any problem
You are for whom?
for petitioners, your lord.
Oh, you want time?
Not because this is the, with regard to revoking of a consent for operation, Karnataka Pollution Control Board. It's a ready mix,
But any,
concrete.
they are the petitioner. They are seeking the setting aside of them.
Your lordships, we are okay with the time being given.
28 to 31.
Let it go in 3rd February, 4th February.
January sometime, your lordships.
So why you are seeking time? Yeah. January, 29 January.
Not serial number
So
42,
28 to 31.
28 to 31, your lordship.
Yes.
That's
So
serial
29 January. Yes.
Serial number 42, lords.
Yes. Yes, ma'am.
My lord, serial
Number 42, lords, and for the approved in this case, lords.
Pardon?
We have complied with the order, lords. We have to file an affidavit. We have informed the other side also, lords. Kindly short accommodation may be given, lords.
You complied with?
Yes, lords, we have complied with the order. We have to file an affidavit, lords.
When you will?
Sure, next week, any date may be given.
16th at 2:30.
Yes, lords.
Se-
Much obliged.
Serial number 24, 24 million, 24.
24.
But I represent R3 in which the notice is said to have been served. I am undertaking to file a power millet. I will inform the appellant counsel. Last may defer it by 2 weeks. He is also present here. 24.
Why?
But I am going to file my wakalat power on behalf of the R3 today. I have to secure instruction papers and submit millet. The last may defer it by 2 weeks. I have informed the other side. He is also present.
Notice is already issued?
Yes, millet.
So, at the request of learned advocate Mr. So-and-so, who wants to file his wakalatnama on behalf of respondent 3, stand out which date?
Let 2 weeks your last meeting.
2 weeks. 11th February.
Please.
Serial number 35. Serial number 34, my lord.
Yes.
Serial number 34, my lord. Please.
You want to mention?
Serial
Do that,
number-
yes, in line.
Serial number 26.
20?
6.
Oh, yes.
Appearing for appellants, my lord, the learned counsel is not feeling well.
12th of February.
Thank you, ma'am.
Serial number 34, my lord.
34. Yes. Pardon?
1 week.
34, 1 week. Why? So all matter goes, then we will also go to our chamber. 34. Why you want green? Senior is not well. So 10th of February.
Serial number 14.
14. Yes. Not in mentioning, let it.
Your-
go.
Lords, one PIL matter of the year 2021 where I had sought, my lords, my lords, are directed it on listing on December 12th. It is not listed, my lords. I'm moving another memo for that reason.
What is the subject matter?
My lords, I have sought a direction for construction of road by way of implementation of sanction that is already been done by the government in Ullal area of Mangalore.
So writ petition number.
28th February,
Lords,
January,
any in the January,
28th January.
right?
The number.
Your Lordship, serial number 41.
To give Mr. Counsel, to give number to, so that he can take.
Yes, Madam.
Serial number 41, Your Lordship.
Okay.
It's a contempt petition. I am for the complainant. The accused counsel is also, the parties are underway in the process of mediation. So it may be posted for next month.
It was stated that the parties are engaged in the process of mediation to resolve the issues between them. In that view, request is made for adjournments. Full stop, stand over to when? 2 weeks?
February, any date may be good.
February,
Because this is the second round of mediation.
13th February.
Much obliged. Your
I am working as a library supervisor. This is the threat of remaining enforcement.
Pardon?
I am now presently working as a library supervisor. There is a threat of removing from my job.
Rate of termination. Rate of what?
Threat of removing from my library supervisor.
Everything has come.
Termination. Termination.
Okay.
It is appeal.
Writ appeal.
Writ
Writ
appeal.
petition and revision petition has been dismissed by
21st. Yes.
Any mention through VC, sir? Sir. Fresh content matters, seal number 1, Mr. Prakash RB.
With regard to gratuity amount is concerned.
It is connected with the other matter.
My lord, that writ appeal is dismissed, my lord. This is connected with 200, man. 199 is connected with the 200.
Where is that? Because of two petitions.
Please,
Why two of contempt?
my lord, gratuity amount was ordered from the honorable, from this honorable court. I would like to take lordship's attention to the
No, that is all right, but why there are two contempt petitions?
wife and husband, man. Husband and wife.
The order is common order in two writ petitions.
But separate petitions, separate writ petitions were filed.
Therefore, two contempt
So,
petitions.
so there were separate orders, man.
Therefore, two contempt petitions.
Yes, sir.
Notice written. Appeal is already filed. Appeal also filed. Appeal is also filed.
My lord, appeal is filed, but it is dismissed, my lord, 375.
We issue
Writ
notice.
appeal is dismissed.
Here we issue notice.
In the cause list,
Whenever.
notice may be issued, my lords, because it has been dismissed. Writ appeal by the private respondent has been dismissed.
Appeal, notice returnable on 4th February. Both. 1 and 1.1.
Seal number 2, Mr. Sarup T.
Same matter.
Connected matter.
What one?
Two.
Seal number 2, Swarup.
2 is not connected.
Lord, I am for the complainant.
What is not paid? Rent is not paid or arrears is not paid?
Arrears is not paid, my lord.
Rent is paid.
Rent is the arrears, my lord. The direction, my lord, is that the writ petition in the.
So rent is regularly paid.
He's been evicted. Before evicting, my lord, the direction was that he has to pay all the arrears.
Only
Page
arrears.
Page 17, my lord, last paragraph.
Then arrears are for which period?
Page, my lord,
Arrears are for which period?
the memo of calculation, my lord, at page 21.
51.
Page 21 is the memo of calculation from 28/12/2013, my lord, to 23/2023. Page 22, translated copy of the memo of calculation.
Up to 20th/3/23.
And that is when he
92
evicted.
lakhs 599. Now the order was passed in 22. Correct?
The 28th
Direction.
October 2022.
2022.
And the time was given till 30th of March 2023 to vacate.
And this is filed within 1 year?
Let-
This contempt is filed when?
This contempt is filed, my lord, 22nd of April 2024, my lord.
Authorization.
Much obliged.
5th of February.
Much obliged.
It's number 3. To Venkatesh
Next, we have
Reddy.
complied, my lords,
Sorry, my lord.
this Hakku Patra has been issued.
My
Lords,
lords,
there is a issue between the
Please, I'm appearing.
authority. Senior is up.
appearing for the clerk complaint, my lords. It's for allotment, direction to allot the alternative land, my lords. Now they have, and to put them into possession. That is the direction issued, my lords. According to the instructions, they have not been put in possession, and what they say is, my lord, we have searched for an alternative land. And these are the landless persons who have lost the lands, my lords, for the scheme of the government. The specific direction has not been complied with the instruction, my lord said, they have not been put in possession. Direction is to put in possession. Earlier also, they allotted some site which was not at all available.
Hakku Patra has been issued, my lords. Your lordship may kindly see paragraph C of the order passed by the learned single judge. It is with respect to such sites. I filed my compliance affidavit, my lords. Page 2 of the compliance affidavit reads the operative portion of the orders.
Page?
Page 2, my lords, of the affidavit. The Deputy Commissioner Chikmagaluru District shall consider the representations after holding necessary inspection and decide on the petitioner's request as aforesaid within an outer limit of 4 months from the date of receipt of the representation. If the sites are available in the concerned petitioners shall be put in possession of such sites within time permitted by the Honorable Court. And if sites are not available for any reason, the Deputy Commissioner must take measures to allot alternative sites to the petitioners again within the time allotted by the court. Now, these two complainants, we have proceedings have been drawn, which I have enclosed, my lords, at annexure R1. And pursuant to which the Hakku Patra of the sites 50, measuring 50 feet by 80 feet has been issued.
My lords, they are required to be put in possession, my lords, not in put in possession. Paperwork has been done. Specific direction is to put them into possession after granting the land. Your lordship may kindly see page 34.
Hakku Patra is a title document, my lords.
Earlier also title document was given, my lords, but there was no land. Let them verify, my lord, when they have put in possession. We are not in put in possession. Let the official submit, my lord, accused respondents, my lords, whether they have put in possession. They should put the concerned allottee the grantee in possession, which they are not done.
So where is the compliance?
My lords, this is Hakku Patra, my lords.
Is Hakopatra not part of the your
Affidavit. Now it has been issued, my lords. Therefore, I am producing before this
Right.
honorable court. This is another set. Two of them.
Then possession, who's in possession?
Nobody is in possession, my lords. These are all site formed for the set purpose.
You
And they have been-
formally hand over the possession. That is the direction. Call him and draw a Panchanama or Mahazar, whatever you.
Very well, my lords. We will do that.
Yes, Mr.
Please, my lord, let them do it and then come submit the compliance report. The very poor persons, my lord, the small sites for the landless persons which has to be given, my lords.
Following were the directions passed by learned single judge in his order dated 16th March 2022. Disposing of the petition along with the other petitions. Thereafter, court directions at page 34. Internal page 24. C bracketed. Which are complaint for the non-compliance in this contempt petition, then court. Respondents have appeared and filed their compliance affidavit. Furthermore, in course of the hearing today, learned additional government advocate Srimati petition produced
This is sanction letters.
copy of sanction letter dated 15/10/24, whereby site number 441, survey number, site being survey number 441 is allotted to the complainant.
Please,
Full stop.
measuring 50/80.
Learned additional government advocate wants said sanction letter to be produced on record by filing affidavit, for which she seeks time. Time is granted. Learned advocate for the complainant, Mr. Paragraph, so and so submits that the direction of the learned single judge is to hand over the possession of the site, which is yet to be handed over. In this regard, it is stated by learned additional government advocate that the formal process of handing over of the possession of site survey number 441 will be undertaken and the possession shall be handed over after intimation to the petitioner within 15 days.
3 weeks, my lord, sir.
By 3.
Very well.
Within 15 days. Full stop. The petitioner shall
It is site in survey.
cite in survey number 441. The petitioner shall remain present and shall accept the possession as stated by his learned advocate when called and when intimated and called by the authorities for the purpose. Full stop. So we dispose of the petition, Mr.
No, there is a, my lord, I humbly pray your lordship may kindly await their report, my lords. There is yet another case where a similar, same connected matter, my lords, their question is not given.
Yes, stand over to 29th January to be listed at 2:30.
Yes, one matter, my lords, the same matter, same facts, your lords may kindly permit me to give the number, my lords, may be called along the same matter, same order. There
Which
more,
one?
one more LRT, one more complainant, my lord, there are other.
Which one
CCC 127 of 24, my lords.
is listed today?
No, my lords.
This may also be called together, same order, my lords, arising from the same order.
Get it listed tomorrow.
Please, my lords. Great.
Number 4. Archana Murthy.
Complainants, ma'am.
Lords, even here, my lords, their representation has been considered. Endorsement has been issued. my lords. Similar matter.
Liberty to challenge that endorsement, ma'am,
Yes.
because
Direction of the learned single judge was to consider the representation of the petitioner regarding conducting of durasti and body in respect of the land in question. Full stop. When the contempt petition came up for consideration today, paragraph, learned advocate, learned additional government advocate, Mr. stated that the necessary endorsement is issued pursuant to which issued deciding the representation. Also, the factum of decision on the representation could not be disputed by learned advocate Ms. So and so for the complainant. Since the representation is decided, paragraph, The contempt proceeding will not survive. They are accordingly disposed of. Paragraph. At this stage, learned advocate for the complainant submits that the liberty may be reserved for the complainant to challenge the endorsement of the order on merits. Full stop. Such recourse is permissible for the petitioner. However, with regard to that, this court does not express any opinion on merits. The present contempt proceedings are accordingly disposed of. As not surviving.
This is number 5, to Mallikarjun GC.
For the complainant in this case,
Notice.
please.
5, 6, 7, 8.
8. Connected matters 11-3. Other some matters are already,
Pardon?
other matters already rated on 11-3-2025.
11-3.
Please.
11.
Number 9,
Lords, this is the RC symmetry, my lords. And there was a direction to the deputy commissioner, and he had given an undertaking to this court, wherein he said immediately after the injunction order is vacated, all the illegal encroachment will be removed. Nothing has happened, my lords. The injunction order came to be passed on.
Notice 4th February.
Yes,
No, 4th February.
4th.
February.
Great.
this is number 10, Anish Jose and
Identical matters was disposed of by
Yes,
That's
lordship,
right.
my lords.
filed our affidavit minutes.
And in paragraph number 527, my lord, same.
So we can-
Same nature of orders, my lord. It was been produced before magistrate.
The present contempt petition directed against is addressed to, is in respect of the directions received in order dated 4th June 24, alone a single judge while disposing of the writ petition number 13691 of 2024. Learned advocate for the complainant fairly stated that similar directions were subject matter of contempt petition number 890 of 24, which was disposed of by order dated, which was disposed of by the division bench of, by coordinate bench of this court, by order dated 21st November 2024. Following was observed while not entertaining the contempt petition. Paragraph 5, 5.16 and 7. The reported from this. Putting this back. Providing that the similar observation will govern the present case also. The present contempt petition is not entertained and stands dismissed.
It may be disposed, my lord. The other matters also made us dispose.
And disposed.
this is number 11, to Srikanth M.
Yes.
Number 11, Srikanth MP.
Applications are invited or not? Who is there?
Number 11,
Ask it over.
number 12, Amit M. Hegde.
The BDA shall have to execute the sale deed within the time stipulated, my lord. The operative portion of the order is at
Notice written on 10th February. Okay.
Number 13, to Narsim Rajesh.
For the petitioner, my lords, there is a delay of 422 days, my lord. Here, my lords, I was the contractor for the respondent number 1, my lords, and I have performed all the work what was given as per their order dated 24/7/2010, my lords. The payment has not been given to me. Later, I have given 3 representation and they have not considered the bill, my lords. Then I filed a writ, my lords. The order has been passed to the respondent to consider my representation. The representation has not been considered yet, ma'am.
So when did you serve the copy of this order
Uh,
to them, to the respondents?
Immediately, my lords.
Immediately, which date?
My lords, they were the party to the writ petition.
This is, give the Contempt of Court Act. Section 20, which is that limitation for filing contempt. You have to come before the court 1 year from the date of expiry of how many months? 6
My lord, 6 weeks time was given.
calculated from the date when you served the order. So we are asking about the service of the. Otherwise, this is hopelessly barred. Not hopelessly, it is barred, it's barred. Read section 20 of the Contempt of Courts.
Please.
You.
My lord, I am not aware when the order has been, it may be posted tomorrow, my lords. I'll seek instructions.
So mere giving of revision will not extend the period. You may serve the copy or file representation after 1 year. That will not extend the period of limitation.
My lords, the representation,
Go through pages. Have you read section 20?
representation as in bill was given it is there in annexure B, C and D.
2024.
No, my lords.
That will not extend.
2019, my lords. My lords, the representation, earlier representation was given in 2019, that is on 7/12/2019, 9/12/2019, and 30/10/31/2020
But you served the copy immediately.
of the orders of the writ petition.
Immediately. Immediately.
My lords,
Tomorrow.
please, my
It is
lord.
liable to be dismissed only for your satisfaction. We are keeping it.
Oblige me. We can try.
To find out the date of service and then
Please, my lord.
also find out how section 20 will operate against you.
Please,
Correct?
my lords. Much
2:30, tomorrow 2:30.
much.
Green bench matter, seal number 14. To Manjunath G. Kandekar.
14, that same order to be passed.
Waiting for petition in this case, same, be disposed of manner. Similar basis.
The same order, except name of the advocate of the petitioner. Date will change and some paragraphs have changed. So disposed of. Thank you.
Writ appeal matters, still number 15. The state appeal.
Lord, it's a government appeal, my lord.
Delay,
There's a delay of.
very large,
54.
large delay, 554.
Lord, there is a connected writ appeal, my lord. In 1367 of 2023, where notice has been issued, my lord, same issue is involved, my lord. The matter relates
In
to,
appeal notice.
please, my lord, there's a
Then this
connected writ appeal.
Notice will have to go here.
Please, my
Lord, learned advocate, learned additional government advocate, Mr. Harish, for the applicant. Post of notice shall be issued in the delay condemnation application returnable on. When the.
It may be tagged along with writ appeal 1367 of 23, my lord.
Since returnable, notice shall be issued in delay condemnation application, full stop. Since it is stated that in the connected date appeal number
1367 of 23.
1367 of 2023. Notice is issued by the court. There shall be notice in the writ appeal also pending condemnation of delay. Full stop. The present writ appeal and the delay condemnation application shall be notified along with the connected writ appeal number. So and so.
Right.
Number 16. Mr. Shekhar L. Number 16.
Keep back. Password.
Number 17. Murthy.
My lord, my
Delay of 9 days.
yes, my lord.
So any private party is there?
The private party is there, my
Is
lord.
there? Where
Yes, the
will
first respondent has, land was granted only 7 guntas in favor of, the first respondent, my lord. But the revenue authorities affected Kata to the extent of 31
4,
guntas.
5 and 6 are required to be served. Notice returnable on 12th February.
Published.
Still number 18. To Vinay Kirti M. Still number 18.
For respondent, my lord. My lord, the writ appeal become infraction.
Infectious.
Yes.
How? That election, no,
My lord,
the caste certificate. Caste certificate. Caste certificate.
It is a
So
caste
what happened?
My lord, even that vacant position has been, election has been conducted and even that vacant position has been filled up, my lord. Vacant position has been filled up. The other one others has been elected as a councillor for that position. His post has been cancelled, my lord, invalidated by in the petition.
Then new
So
fresh
that's what-
election. Fresh election is conducted.
Yes, ma'am.
So he has to file election petition.
Yes, ma'am.
If at all he is aggrieved. He has to file election petition. Now,
No,
My lord, the election was invalidated by the
Correct.
Leonard
Now,
single
fresh-
judge, my lord.
fresh
Now he
election.
says the term, the post has been filled up now, my lord.
Filled up.
Therefore, it has become infructuous.
yes, right, if he wants to challenge that new election, he has to file election petition.
Yes.
Where is, yes, you are there?
No.
Why? Why you are not there? If you are there, we'll dispose it. Pass it over. Come in the second round.
This is number 19. The Nandita, the health report.
The appellant in the matter. This matter, the connected matter is posted on 30th January. The same common order has been challenged in that order also.
Which January?
30th January. So notice may be issued in
In
this.
view of the
because there is
statement made by the writ appeal number
887 of 2024.
887 of 2024 arising of the same judgment and order is
Your lordship may
going to
kindly
be
issue
posted on
notice.
which date?
30th January.
30th January.
30th January. There shall be notice in the present
I take notice for respondent number 3.
as well as the writ appeal returnable on the same date. You are accepting the notice.
Respondent number 3, my lords.
Learned advocate Mr.
Kumar MN.
Kumar MN accepts notice on number 3.
Published.
Respond number 3, yes.
This is number 20. To Uday Prakash.
Notice delay, notice returnable on 17th February.
Great.
permitted to take notice on behalf of the respondent number one.
Learned advocate Mr. So-and-so accepts notice on behalf of respondent number one. The rest of the respondents shall be sought. Next,
Great.
21.
Short date may be yours. Short date may be given. Short date may be given. Your worship.
Date
Request
is
for,
17th February.
the reason is this, your worship, the term of the license is going to expire.
Term of?
Term of the license period, your worship, is going to
Yes,
expire. That is.
when it is going, when it is.
Worship, they shortly should already, your worship, verge of for expire. That is the reason, your worship.
If in the verge of expiring, then there is no way out. Anyway, earlier even, 28th of January.
Please.
This is number 21, Shrikant MP. Number 21, Shrikant MP.
I pay for the respondent. There's a delay of 132 days. which is
So you appear for all the respondents?
May be permitted to file my objections to the.
That's right, but you are appearing for all the respondents? Appearing for all the respondents?
Yes.
All.
Yes.
So what is the delay?
So serial number 75, the respondents have filed.
132 days delay. Delay of 132 days. So
So I'll file my objections. No reasons as such given except accusations.
file over. Notice returnable on 3rd March. Learned advocate Ms. So accepts notice and seeks time to file, accepts notice on behalf of all the respondents and seeks time to file a counter to the prayer for condolence on delay. Accordingly, stand over to which date?
3rd March.
3rd March.
22,
22 is
Same order, identical.
serial number 23,
Serial number 75 is pertaining to the same matter in which the respondents have filed their appeal.
writ appeal number 1348 of 24. Arises out of the same order. Therefore, the said appeal shall be listed along with the present matters on the next. Both will be listed together. Both the appeals will be listed together.
Emperor the appellant, your lordship, some.
Where?
Then see my senior.
In which matter?
Lordship in serial number 21, 22, your lordship.
So we have issued notice in the delay. And the council wants to file reply.
Lordship, in this matter, in this month, the appellant is retired, your lordship. That's the reason. Urgency, your lordship. Serial number 75 also. Connected matter, final hearing is there, your lordship.
Retiring, when?
Yes, sir.
When is it retiring?
I think this month only, your lordship. Very urgency, your lordship.
So you file your counters before, we'll keep it on 22nd of this month.
Matter, my lords, 21, 22 and 75, my lords, some urgency, my lords, in fact, my lord, they were listed prior to vacation. I'm retiring, my lords, by this month end. Matter pertains to, my lords, my promotion, my lords, as a flight test engineer. I'm, my lords, made to sit out of the post, my lord, from 2017.
No, this, 21 and 22 is filed by whom?
My lords, filed by me. My lords, the common order was passed. My lords, against the same, my lords, order. There were two petitions, not 96.
Oh, madam, since there is a cross appeal, we condone the delay right now.
Please.
There is a cross appeal entertained, so this is bound to be condoned.
75, my lord, serial number 75.
75.
21 and 75 are cross appeals.
So since there is a cross appeal by you, then the delay in their appeal may be condoned. There is no point in filing reply.
Lordships, I need to
need to file my objections in this.
What objection?
Lordships, the tone and tenor of the petitioner.
No, we'll not
the
read.
appellant.
We'll not read the
Lordship,
tone.
there's no
We'll not
grounds
read.
at all, and fully walk in and make accusations. Lordships may kindly give me
But he is retiring.
Lordships.
He is retiring by the end of this month. So some regard will have to be given to that aspect also. You want to file,
Lordships, as far as this promotion.
when you are
is
going to file
concerned,
reply?
Some promotion which does not exist.
That is a matter of merit, but he should not be deprived of hearing when he is.
Posted on 22nd is fine.
So file reply by that.
Lordships,
File your reply before that date.
right. Your Lordship.
Lords, can it be little earlier, Lords?
Earlier, when you file a reply within, this is right, we'll dispose it of the matters.
The order passed, request to be implemented also.
Earliest is 17th of January,
Oh, bless.
17th of January.
Oh, bless. Lord, see number 20.
Reply shall be filed before next date. It is observed that in the facts and circumstances case, even if the reply is not filed, the court may be inclined to take up the delay conversion applications.
Lord, see number 21, 22 and 75 be.
In accordance with.
It may be listed along with, my lords, this, my lord, along with this, see number 22 and 75, my lords, may be listed. 75, my lords, is as the, my lord, in front.
All will be listed on 17th.
Please,
All.
please, in the, my lords, in the same stage, my lords, in the same stage, my lords, otherwise, my lords, on that
I
day.
will take up.
Please,
Reminders.
please.
Number 23. So Prashant, it is. Number 23. So Prashant, HS 23.
My lord, for serial number 23, my lord. My lord, am I audible, my lord? Hello.
Once you argue, you will be audible.
My lord, serial number 23, my lord.
Yes.
My lord, press time, my lord. Senior is not well, my lord. Senior is not well, my lord.
You are not audible.
Serial number 23, my lord.
No, you are not wearing your gown also? Gown is taken away by senior?
Yes, my lord.
What is this, Mr. Counsel? Appearing without gown before the.
Apologies, my lord. I just.
No apology. Dismissed on the ground that the counsel is arguing without gown.
No, my lord, please, my lord, please, my lord. Lords, please, my lord.
Still you are arguing without gown.
Just a second, my lord.
I would have, in your place, I would have just got up and gone to take the gown, running to take the.
I'll go, my lord.
That's correct. So we'll adjourn, simple. 23rd January. He's really.
This is number 25.
24 का क्या हो?
24 is urgent. 25.
Appearing for respondent number 5 and 6, my lords.
Short question, my lords. The petitioner, or the appellant, my lords, was before the revisional authority by filing a petition saying that, my lords.
Delay.
Yeah, 71 days.
We'll file objection for the delay. There's a 71 days of delay, my lords. We'll file objection for that.
IA number 1 of 24. This application is filed or learned counsel to the respective parties. Paragraph. This application is filed seeking condonation of delay of 71 days, which has taken place in hearing of the appeal. Paragraph. The affidavit accompanying the application explains the reasons which led to passage of time and the delay in filing of appeal. It is stated by the appellant applicant that because of his financial constraints, he could not come to Bengaluru to instruct the lawyer and could not manage the fees. It was also stated that large number of documents which were in vernacular were required to be translated, in which process also further time elapsed. Full stop. The respondent has filed counter objecting to the condonation of delay, objecting to the prayer for condonation of delay. Full stop. Looking to the fact that the petitioner, applicant petition comes from the lower strata of the society, and having regard to the ground put forth, it could not be said that he whiled away the time out of any negligence or culpability. In the circumstances, sufficient cause is made out, delay deserves to be condoned to the extent of 71 days. It is condoned, application is allowed. So now, appeal today or any other day?
Lords, short question, Lords. I sought for Lords payment of salary in accordance with rules. The revisional authority says as paid to the other employees, it has to be paid. I challenge that by filing a writ petition, and it is Lords contended by the other side saying that Lord, the provision which I am placing reliance upon is held to be Lords unconstitutional by the division bench. But I bring it to the notice of the court that that order is stayed by the Honorable Supreme Court. As such, the rule will continue on the rule book. But unfortunately, my lord, the learned single judge says, my lord, the status quo would maintain and will proceed as if the rule is held to be unconstitutional, which is not correct.
It may be heard as part read, my lords. We'll argue in the coming days. Very short date, maybe accommodate. We'll also argue. Seeking a
What was the prayer in the main petition?
It's to pay salary in accordance with, my lords, the rules.
You're seeking payment of salary.
Salary, my lords, in accordance with.
And contempt is filed? No.
No, my lord.
Why you are seeking?
Dismissed, my lord.
Not ready. You overheard our discussion. Why do you want time? Why do you want time?
And that's senior is in Supreme Court today. Man.
Senior is in Supreme.
I was, my lords, it was a short date maybe, and I'll prepare well.
Already on legs. Senior is on legs before the Supreme Court.
Not in that regard, my lord.
Traveling.
I joined very recently, my lord. I am not aware of this.
No, where is your senior? Senior is traveling or is already in the courtroom of the Supreme?
No, he's in the, he's traveling.
Travel.
He would have reached by now.
By noon he will reach. Very good. Day after tomorrow?
Great. Yes.
16th?
Yes, no.
16th.
Grateful, my lord.
26 urgent, still number
16th,
27.
we are keeping it 2:30, having regard to the, write down, having 25, having regard to the
26.
compass of the controversy and the issue involved. Seen by the court with the assistance of learned able parties, comma, put up on 16th at.
26 minutes we are there. It's adjourned, I'm told.
Which one?
26.
26 is the adjourned.
My lord, may I make a submission, my lord?
I just.
No, no, my lord, it's serial.
There's an
number
interim order, my lord.
What are the matters? Because
serial number 26.1 and 26.2 have been tagged with these batch matters, my lord, but our matter is not connected with that.
But what is 26? Let us see. We did
The
not.
PID matter, my lord.
Some matters are regarding land acquisition, my lords, where 28(1) was issued and final notification was not issued after a lapse of 19 years, my lord. Now subsequent development is, my lords,
But
now
somebody got it adjourned without our notice. At this so many matters.
My lord, in that case, serial number 26.1 and 26.2, it's been tagged because, sir's writ petition.
1150.
1150 of 22. It's because of typographical error, it has come about as 1150 of
50,
23.
ma'am.
And it has been tagged with
26.3.
these batch matters. So 26.1, 2 and 3, 26.1.
26.1, 26.1.
1, 2 and 3 has to be taken.
Is the KID.
26.3 number. Oh, yes.
26.1 and 2, my lord.
So 26.1 and 26.2, that is writ appeal 803/22
And 949.
and writ appeal number 949/22.
Yes.
Learned advocates for the parties appearing these appeals are ready to submit that these appeals are not connected with writ appeal number 1056, 1057 of 2024 with which they are notified. In that view, writ appeals number 803/22 and writ appeal number 949/22 shall be
Clubbed along with 1150, my lord.
Of 2022.
2022, my lord.
It's written as 20.
shall be segregated and shall be placed before the abbreviated court in accordance with the roster.
Yes.
Full stop. It was further stated that the connected appeals are
RSA 1150 of 2022, my lord.
22.
is 1150 of 2022, which shall be listed, with writ appeal number 1057 of 20.
Which has been, no, my lord, my lord, I'll just briefly state. 849, 949 and 1150
Yes.
22 are three matters which are clubbed together. Now, what has happened when this honorable, when the order was typed out,
Aforesaid
came
two
about as
Aforesaid
1150
two
of
appeals.
23, my lord. Hence, it's come up
Aforesaid
with
two appeals number 883 of 22 and writ appeal number 949 of 22 shall be listed with connected writ appeal number 1150
this. 22.
of 2022.
Yes, rest of the appeal, my lord, may be deleted, my lord, from the.
To be placed before the appropriate.
Yes,
bench.
ma'am.
Yes, my lord.
But
Rest of the
there's some interim order, my lord, my lords. May I
interim extended.
In 26,
Yes.
interim order shall stand extended in 26.
Then
Yes.
three matters in 849, 803,
In these
949 and 11.
In
Yes.
these,
Same matter, my lords. I have filed
in
an
all the
application
aforesaid three matters, the interim order which is already operating shall continue to operate till the date when the appeals are posted before the approved bench.
Please.
Yes.
My lords, in serial 26.
Now, what about 26 now?
My lords,
26, my lords.
No, now we are on 26.
Yeah.
949.
It is adjourned. Lords, 26.3, because these are the land acquisition matters, my lords, where 28(1) was issued.
Somebody is prayed for time. What is when? We'll prepone it instead of 12th February, 28th of January.
12th February. 12th February, adjourned to 12th.
Now we are preponing it.
Yes,
since
my lords.
They are not taken consent.
Much of it.
Yes, inform the person who has counsel.
I'll inform him.
One order, my
But
lord,
some
impugned order,
some
the writ
orders are-
petition.
Lordships
The
have
writ
passed on.
petition, my lord, the lordship
One or two
has
matters.
passed the impugned order, my lord, in this.
one or two matters are passed, my lord.
Passed by lordship. An entire group will go, not to be placed before the bench, where one of us, Celebrate Honorable Justice M.I. Arun, take it to her, is a member.
Some of the writ petitions.
Then it is a group.
Correct.
Yeah, group, my lord.
So all will go.
Or say any date, my lord.
The registry shall list the appeals at the earliest before the appropriate bench.
16th or 17th, my lord.
It will come to me.
Because what has happened, my lord?
It will come to the Chief Justice on admissive.
Yes, my lord.
We'll say that in 17.
Much.
Just pursue with the Registrar Judicial, so
Yes,
that.
much.
Case number 27, Mr. Srinivas V.
My lord, I appeal for petitioner. My lord, as per the instructions, my lord, I was supposed to file an impleading application to implead the deputy commissioner and the assistant commissioner. But my lord, they are parties before this. In this case, they were arrayed as respondent number 5 and 6, my lord. So when the learned senior counsel argued in 2021, we were under the impression that the deputy commissioner, who is the head of the Ashraya committee, have not been arrayed as a party. Therefore, we were directed to implead the deputy commissioner. But now, my lord, when we check the file, deputy commissioner is a party, my lord. May I seek for a date, my lord, so that I'll see I can get the senior counsel for arguments, my lord, in this case.
Deputy Commissioner?
He's a party. 5 and 6, he is there. 5 is the deputy commissioner and 6 is the assistant commissioner. I seek for a short accommodation, my lord. Today, the senior counsel is not available. May I request for one short accommodation?
Will grant, but very old matter.
Yes, my lord. Any date, any convenient date may be fixed, my lord. So,
These are public interest.
yes, my lord, this is a public interest petition wherein the allotment of sites under the Ashraya scheme have been challenged to the private respondents on the ground that all the private respondents are having the separate properties. We have produced all the materials to show that they are having properties. In spite of it, they have been granted the sites under the Ashraya scheme. And also on the ground that the Ashraya scheme have been held unconstitutional by the Honorable Apex Court. There are 2-3 grounds, my lord. Learned senior counsel will argue, my lord. May I seek for a short accommodation?
Please, my lord, this Hakkupatra is issued by executive engineer, please, my lord. It appears on the last occasion, he was directed to made as a party. Executive engineer has to be made as a party, not the deputy commissioner or assistant commissioner, please, my lord. Hakkupatra was issued by executive engineer Taluk Panchayat Hasan. He has to be made as a party. That is the reason matter was that. My learned friend is saying that the deputy commissioner and assistant commissioner are already on the party as a respondent number 5 and 6. That is not the
Since
case.
it was a 21 matter, my lord, but senior colleague is informed that it is deputy. If that is the case, I will make executive engineer also as a party, my lord. I will make him as a party.
30% January.
Much.
When 35?
30 minutes. Number 28 to 31 are urgent. Number 32. Nayak Narayan Mustafa. 32.
Pass over. What is it about?
This is a matter, my lords, if my lords may recall, the petitioner had challenged the withdrawal of consent on the ground that his premises comes outside the CRZ unit. My lords had directed an inspection and it came to write that my lords, half of his unit is inside the CRZ.
Some part is.
Yes, some part is outside. My lords, a corresponding proceedings was also pending before NGT. And my lords, in NGT, he has given an undertaking that he is dismantling the entire unit itself. In light of that, my lords, none of these petitions may not serve. May I just pass the NGT orders?
May I make a submission, my lords? In 32.1,
I have filed my NOC Makalat. My name is not shown, my lord. That's why I'm not ready. Just now I've been informed that the matter is listed.
But how you are here if your name is not?
My name is not sure. The previous council has informed me just now, my lords, that the matter is
In any
listed.
event, it is the same council who's made the submission before the NGT. My lords may see the order at paragraph number 3, my lords.
It's not dispute that I am not disputing that I am the person who's appearing before AJT.
And then,
Lordship,
my
give me
lords,
just 2 days time. I will make my submissions, my lords.
Where is the demolition aspect?
my lords, he says in paragraph number 3, my lords, the learned counsel appearing for first respondent also vouch that no activity is happening and the machines installed are already sold. My lords,
So
for-
nothing will survive.
Nothing will survive in all these petitions, my lords, and especially 32.2. That, my lords, is actually saying that, my lords, not to, it's a PIL which has been filed. Saying that, my lords, this activity should not continue.
But my instruction, my lords, I appear for the petitioner in the public interest litigation. This is the complete order, my lords, of the honorable NGT. May I just pass this on, my lords? There is a direction for closure of these 2 units, which has not yet been complied with, for which we are following up not separately. But the petitioners in that PIL, they're all, my lords, children studying in a primary school, my lords, which is located right next to this offending unit. Not the offending unit are 2 units in numbers, one run by the husband and the other run by the wife. Not one, my lord, is a fish cutting unit. The other, my lord, is a fish powder unit. So what happens, my lord, both are export oriented units. In the fish export oriented unit. So in the fish cutting unit, what happens is the freshly caught fish are processed, they're canned, and my lord, they are prepared for export. In the fish powder unit, what happens, my lord, is that the fish entrails, the waste, my lord, which comes out of this fish processing process, they are dried, they are powdered, and my lords, then they are packed. Now that entails, my lords, creation of a lot of nauseating smell and my lords, smoke. So a complaint, my lords, was filed on multiple grounds. One ground, my lords, is the pollution that is being caused. The other ground, my lords, is that this units are located well within the prohibited zone of the CRZ. Thirdly, my lords, what has happened is, my lords, the fish cutting unit, they have secured a permission to establish an ice plant. That's quite interesting. The state has to answer that. The permission that has been secured from the government is to establish an ice plant. But then the operation, my lords, is quite different. What they're actually doing is something quite absolutely different. And the conversion order also has been cancelled.
Correct.
Notwithstanding which, my lords, the units are still functioning, my lords, the state has to reply. The role of the PCB, my lords, may be over to some extent.
That's the consent has been withdrawn. Closure would be a consequential action. I would just want to say that because consent.
Sir, your PIL is not serving.
I have 2, I will make my small submission, my lords.
Yes, I would concede, my lords, that what I had asked for, my lords, has been indirectly granted, not through somebody else.
So we dispose of right now.
Lords, may I make only one request? There is a direction by the NGT, my lords, and also the indulgence of this honorable court, my lords, the learned single judge, whose appeal is in question in the writ appeal, has clearly passed an order for closure of these 2 units. Lords, I would only request my lords to issue appropriate directions to the state in light of the NGT order. That is all that
I may suggest to take action in accordance with law in terms of NGT order.
NGT order.
We'll do it, my lords.
That would suffice.
That is what was contested, that NGT order says that we are doing otherwise. Now, my lords, the submission of the industry itself is that we have sold the machinery. There's nothing surviving there.
May I make a submission, my lords? Because I have been appearing in the NGT.
So far as the first petition is concerned, my lords, it should be dismissed. Insofar as the PILs are concerned, my lords, in light of all these developments, it should be disposed of.
Let the petitions come.
Please, my lords.
I'll just make a submission, my lords. Regarding the order in NGT, the unit has been closed for the past 2 years. So nothing survives. And the machinery has been sold because I am appearing before the National Grid Tribunal. So machinery also has been sold. So nothing survives regarding the unit 1. So there is nothing. There are 2 units. And my learned friend is making all these things and taking action. When the NGT has passed the order and I have closed the unit, nothing survives, my lords. And the other thing beyond CRZ, CRZ is a 50 meters. Earlier it was 140 meters. Now it is reduced to 50 meters, my lords. That's all those issues are before the National Appellate Tribunal, my lords.
You are for whom?
The industry, my lords.
Industry.
And who is the petitioner?
That's
The
the
industry
petitioners,
itself is the
the
petitioner.
industry itself is the petitioner.
The
The,
writ appeal.
in the, proprietor is the,
So
Yes.
let the petitioner come. Dispose of
in the
it.
lead matter, my lords, the petitioner advocate is Mr. Nagaraj. He is not here.
Who is there?
D. Nagaraj is the advocate for the lead petitioner.
Wait for
Please wait, my lords.
2:30.
I have taken NOC only for Mr. Harish Bandari, my lords, who is appearing in the connected matter.
Number 33. Chidanandaya.
Appearing for petitioner, my lord, I seek for the adjournment, my lord.
Hmm?
Adjournment, my lord, because the
Adjournment.
senior is not available.
Senior counsel is in Supreme Court.
No, my lord, there are some inconveniences, ma'am.
Not well. Senior counsel is not well.
No, my lord, some inconveniences, my lord.
Inconvenient because of this petition.
Apologies, my lord.
When do you want?
After 23.
After
23,
23?
yes, my lord.
At the request of learned advocate for the petitioner, stand over to 4th February.
Much obliged, my lord.
34 is adjourned. Still number 35. Ravindra Gajanand.
Please, my lords. I am a surviving query lease holder. Validity is up to 2037, my lords. And I have been paying royalty and all charges due to the government. Nothing is in arrears. But all of a sudden, the computerized mineral dispatch permits have been stopped issuing without any issue of any notice or observing any things, my lords. Now, thing is, it is covered by the order of this honorable court. I have produced at page number 78, my lords. Page number 78, at paragraph number 9, my lords. Last one sentence I may kindly be permitted to be read, my lords. In the italics, it is there. So long as the mining lease is valid and subsisting, the respondents cannot refuse to issue MDP in respect of minerals lawfully excavated by the petitioner from the lease area. So I am well within my rights, my lords. I have not violated any terms and conditions of query lease.
My lord, before my learned friend can proceed further, my lord, pursuant to his request, my lord, an endorsement has been issued. My lord, I'm sorry, I did not see my learned friend, so I couldn't serve a copy.
I am not been issued or served with any notices.
Sir, I'm
or
giving it to you now, sir. My lord may have this day after. Let him have a look at it and make a.
So there is no endorsement as such, my lords. There is no endorsement. I don't know under which assumption it is being said that an endorsement is issued to me.
No, based on the application filed by you.
So it is only intra-office communication between the deputy director and the director, which has no relevancy to this, my lords. And for that reason, issue of immunity cannot be denied, my lords. That's why I am relying on the not one. There are 3 judgments that have been passed by this honorable court, my lord. I have already produced at page from page number.
Then my lord may have this day after, my lord.
Huh?
Day after.
So how long I am to wait?
Sir, day after, sir. Day after tomorrow.
Till day after.
Please, my lords.
You take instructions.
My lord, I've taken, but since he's agitated, I just wanted it.
Day after is which date?
Friday.
Friday, all right, Friday.
Please, my lords.
So take instruction.
My lord, I've taken, but because he was a little agitated, I didn't want to proceed with the arguments.
Yes.
It's number 36 for the petitioner, my lord.
My lord, in this, my lord, I've got the,
This is pertaining to the daily wage workers, my lord. My friend has served me a copy of the memo where the government has granted approval for sanction of leave, my lord.
So satisfied.
my lord, nothing more survives, my lord.
My lord, there is one pending issue,
Something
if I
is
may
given?
be.
Yeah, it's given.
There's only one pending issue, my lord, that I'd request my lord's indulgence in. There is a matter of arrears from 2012 to 2019. Arrears, my lord. So there was an order of this honorable court on 8/8/2022, as also 17/11/2021, where the aspect of whether these arrears have in fact been paid or not had to be ascertained. This is the only thing that is pending, my lord.
Maybe 8/8/22 and
8/8/2022, 17/11/2021.
So that is very good of you because it will end the heartburn.
my lord, I've got it, my lord. Now, with regard to the arrears, since they were not, they are appointed under the contingency fund. My lord, we are in no way responsible for that, my lord. Fresh demands are coming up.
No, my lord. In fact, this was already on record from 2021. So this is not something that has come up now. In fact, the learned counsel has been very fair.
All petition will not serve.
No, my lord. Now, fresh demands, my lord, if my learned friend had informed me on the last occasion, I would have made an attempt, my lord, to see if something could be done.
For arrears.
My lord, I wouldn't know arrears because they are not appointed by us. They are appointed under the contingency fund.
You are appointed when?
My lord, they've been appointed when the benches were formed. This was in 2010,
Stand contented.
my lord.
Stand contented with prospective. At least we can leave, we can grant liberty to make a representation.
Yes, my lord.
Very well, my lord.
Yes, yes.
Very well, my lord.
So this.
I'm obliged, my lord.
So that arrears from
2012, my lord.
regarding what? Same.
Same, my lord.
Leave.
Not with regard to leave, my lord, with regard to the payment, the monthly salaries, the daily wages.
That is not paid.
Uh,
Salary is not paid.
From 2019, it has been paid at the enhanced rate as much as the permanent employees. Between 2012 and 2019, my lord.
For salary from enhanced, at the enhanced rate from 12 to 19, representation.
We'll
My
make
lord, a
representation.
representation may be given, my lord.
To be decided in accordance with.
In accordance with law.
On and on. So
We'll do
we'll
that.
pass the order.
Obliged, my lord.
Deeply obliged, my lord. I also would like to thank my
Thank you.
learned friend for
Yes.
looking into this with a very humane aspect.
So she has responded to the court's.
My lord had prevailed upon me to see that I get
You
a
don't prevail.
positive.
Don't say
Oh,
that.
no, I'm just saying this, my lord. It's not.
This is holidays only.
Yes, holidays and all. That is the application that they had filed.
This petition was only for, to treat them at the par with.
Yes.
With regard to the
daily wage.
pay that has already been granted by two interim orders of this honorable court, those orders will, the petition may be disposed of in light of those orders.
Where are those orders?
Yes, madam. 27/1/2016 and 28/7/2016, my lord.
16.
Yes, my lord.
Not able to find out your.
Salary. 27/1/2016 and 28/7/2016, my lord. Now pursuant to this in 2019, the salaries of all employees were enhanced, my lord. That enhanced amount was also directed to be paid on 17/11/2021. Eleven, 17/11/2021.
17/11.
2021.
Moved by the High Court Legal Services Committee, in the present public interest petition, the cause sought to be espoused was with regard to equal treatment to be given to Group D employees working on daily wages at the Dharwad and Gulbarga benches of the High Court of Karnataka. In terms of payment of salary, treating them at par with the other employees. It was stated that paragraph. Class D employees employed to work in the establishment of the High Court at the said two places where the circuit benches function. Parity in remuneration was eluded for them. There were about 36 employees working on the establishment of the benches. Most of them were deputed to work at the residence of honorable judges, and that they had put in a reasonably long continuous service. It was contended in the petition paragraph that the daily wage employees had the right to be treated at par. The putting of equal pay for equal work on the ground that they have been discharging the similar nature of duties and could not have been treated differently in the matter of paying the salary and the other remunerative benefits which are part of salary. Most of the proceedings of this petition paragraph witnessed several orders passed by the court from time to time. Paragraph full stop. On 27/1/16, order was passed.
My lord, when the petition was filed, there were 64 part-time employees. Subsequently,
Part-time employees were permitted to participate in the election. They participated.
not in the proceeding, my lord, they were represented by the High Court Legal Services.
No,
Authority.
selection process.
My lord,
Entitled to participate selection process. orders were passed. From time to time, these proceedings witnessed orders passed by the court from time to time. Orders were passed on 27/116, 28/716, and 17/121.
1711, madam.
Citing the material aspects of the controversy, in the controversy. By order dated 28/716. The court observed to negate the stand taken by the state government. The Registrar General was directed to furnish the list of the employees who have been working at the said benches as on January 27, 2024, excluding the 64 persons who were covered by the interim order earlier passed on 27/116. In the ordered paragraph, in the order dated 17/11/21, the court recorded the submission on part of the counsel for respondent 2 that the part-time employees employed at Dharwad and Kalburgi benches have been paid wages at the enhanced rate, and arrears have also been paid to them, which was our prospective, full stop. Today, when the petition comes up for consideration, paragraph learned additional government advocate Srimati Nilofer Akbar produces memo dated 8/1/25, producing therewith the approved proposal of the Finance Department, Government of Karnataka, along with the copy of the endorsement issued by its Honorable One Chief Secretary, State of Karnataka. Full stop. It is stated that the application of the petitioner for grant of holidays to the part-time daily wages, part-time daily wage manual workers working in the benches of the High Court at Dharwad and Kalburgi for the benefit of general holidays during the government holidays
Yes, madam.
is granted. Full stop. The memo accompanies the copy of the relevant correspondence and the orders dated 7/1/25 from the Karnataka government, from the Finance Department, and from the Karnataka Government Secretariat. Full stop. Learned advocate, paragraph. Ms. So and so, the petitioners stated that these orders passed by the state government substantially and largely satisfies the grievance of the petitioners. We however submitted that the issue of arrears of payment of salary at the enhanced rates for the period from 2012 to 2019 is yet to be addressed by the competent authorities. Full stop. In the totality of facts and circumstances, the court finds that since the substantial part of the grievance is taken care of by the governmental authorities by granting the holidays and treating the daily wage employees at the said two benches at par with the other employees, the present proceedings are not required to be continued. As far as the surviving aspect of the arrears of payment during the aforesaid period is concerned, the petitioners concerned, the employees concerned are permitted to make a representation, detailed representation. To whom?
My lord, they were appointed under Rule 7 and 55(2) of the Manual of Contingent Expenditure 1958. So maybe they will have to approach the Registrar General for that, my lord, because we have nothing to do with this.
The General of this court,
Yes.
to the Registrar General. Not
Or the relevant,
forward the
very well.
Registrar General of this court with a make it permitted to make a detailed representation to the Registrar General of this court, since they are appointed under
My lord,
contingent.
Rule 7 and 55(2) of Manual of Contingent Expenditure 1958.
Rule 7 and 55 of the Manual of the Contingent Expenditure Fund. Full stop. Learned counsel for the petition stated that such representations will be made within 4 weeks. Full stop. Once the representation is made, the Registrar General of this court is directed to forward the same to the competent authority of the state government, which shall in turn decide the same in accordance with law, and keeping in view that the employees are treated at par in other respects. Full stop. The court, however, does not express any opinion paragraph about the representation which may be made by the petitioner. Full stop. While parting, the court records appreciation
I'm obliged, my lord.
for the authorities for taking a fair and equitable stand in the matter. The petition stand disposed of in the aforesaid terms.
My lord, may I make
Right,
one
madam.
submission? My lord, the holidays are on general holidays and during government holidays are notified by this honorable court.
It is a
Yes. General holidays and
This
government
general
holidays
and government holidays.
and
as
notified by
notified.
this honorable court in its calendar.
As notified by this court in the calendar.
Obligement.
We'll decide, we'll decide within 3 months. The representation shall be decided within 3 months.
Deeply obliged. ma'am.
Contingency fund and registrar general.
Number 37. Mr. K. and Manjunath, party in person.
My lord, in para 5 of the order which is now sought to be recalled, your lordships have already held that the petition is wholly misconceived and it is an abuse of the process of law. In spite of that, my lord, further applications are being filed, terming your lordship's orders as being baseless. That is what the prayer says. Prior to this, there was another order where, my lord, this honorable court held that it is absolutely impermissible for this honorable court to intervene in these kind of matters.
And Kaveri voter district.
Yes, my lord. There are 4 basin states involved, my lord. So there's a serious question of jurisdiction.
Sir, I am very sorry to say, they are once again misleading very badly. Misleading this court very badly.
Pardon?
They are misleading this court once again very badly.
Very?
Badly,
Who?
respondent side.
Argue review, don't argue about them.
No, sir, sir, now we have filed this recall petition for recall of the order dated 31/5/24.
Yes, 31,
5/24,
31, 1, 530. Yes.
24 in WP number 9903 of 24, sir.
Got it.
Because that order contains very glaring
31-3. Which order is under review?
31st May, my lord.
31/5/24.
31 May.
Yes.
Your lordship's order.
No, 31.
5/24.
This is the order under review.
Another A1, sir. The order contains very glaring constitutional discrepancies and errors.
So first ground is glaring constitutional discrepancy.
Constitutional discrepancies and errors.
Constitutional
Errors and discrepancies.
discrepancy. Then Sir. What are those discrepancies?
I'll tell you, sir. Sir, I want to read the order, page number 10, sir. The order dated 30/5/24. Page number 10, sir. So that you can have a grasp of the matter.
Reading same order.
Page number 10, sir.
10. Where is the review petition? Page 10.
Page 10, sir. Order.
Page 10 of what?
Order dated 30/5/24. In IA number 2, sir. 2/24. IA number 2.
He is referring to page 10 of the IA, of the IA. Basically, he wants to refer to page number 3 of your lordship's order. That is where it begins.
Yeah,
Internal page number is 3.
IA for review.
That Annexure A1, sir. Page number 10.
Page 10, yes.
Page 10, sir. Annexure A1, sir. That is the order dated 30/5/24. So that you can have a grasp of the matter. Para 2, sir.
This is 31st of May 24.
Yes, sir.
So that is the order under review.
Yeah.
31st.
Under recall, yeah.
Read it.
Sir, para number 2. The prayers are firstly to enforce national water policy and water allocation priorities as mentioned under clauses 7 and 17 of the Ministry of Water Resources Gazette notification dated 19/2/2013 as ordered by the Kaveri Water Dispute Tribunal. The second prayer is to release water from Mettur Dam for Samba crop during August, September and January, February as ordered by the tribunal in the award. The third prayer is to enforce the tribunal's direction in volume 4, chapter 2, facilitating and growing of minimum one crop by farmers of both the states, binding under Interstate River Water Dispute Act 1956. Para 3, the premise of the aforesaid prayers in the pleadings is that there has been breach and non-compliance of certain directions given by the Kaveri Water Dispute Tribunal relating to water and release and water distribution. That is, para 2 and 3 are very beautifully recorded.
What?
By this court.
So then why you are filing review?
No. Sir, that is where the matter lies.
What is beautifully recorded?
Facts in accordance with the Interstate Water Dispute Act.
Yes.
That the whole case is revolving around the Interstate River Water Dispute Act. That is, if you kindly uphold the Interstate River Dispute Act, my prayers will be met, sir. Sir, para 3, sir. The premise of the aforesaid prayer in the pleadings is that.
By the way, you are a retired person or you are serving some?
Retired, sir.
Yes.
Sir, now, my problem starts from para 4. Both learned Deputy Solicitor General of India, Mr. Shanti Bhushan, for respondent number 1 and 2, and learned additional Government Advocate Nilofar Akbar for the respondent state, objected the prayers in the petition on the ground that the dispute falls at the best in the realm of jurisdiction of the tribunal, and judicial intervention in the writ petition or in the public interest petition is not called for. Also, it was pointed out that in the similar subject, a matter by the same petitioner, earlier writ petition number 242/23 was filed, and that the same was not entertained by the coordinate bench of this court as per the order dated 17/11/23. Next, para 4.1. In respect of the said order, content petition was filed in CCC number 131 of 2024, which was also not entertained by observing that the provisions of the 1956 Act enacted by the Parliament would attract, and that the Kaveri Water Dispute Tribunal has already been functioning since the issue touches the jurisdiction of the tribunal. So next, para 6, sir. Para 6.
No, para 5, para 5 is important. He's skipping para 5.
No, no, I will come to that, don't worry. I
Para
will come
five.
to every point. Okay, I will read both that. The court finds that the present public intention is not only wholly misconceived, it is in a way also abuse of process of law. It could be also submitted on behalf of the respondents that one of the prayers relates to enforce the release of water from Mettur Dam, which is located within the jurisdiction of the state of Tamil Nadu, be that as it may. Sir, they are referring to file only to mislead you on it. Sir, para number 6, sir.
There 6.
Para number 6, next. The issues are outside the purview of the writ court. Now the petition could be entertained as in public interest litigation. The court could have dismissed the present petition with cause. However, desist from imposition of any cost since the petition has been appearing in person. Accordingly, the petition is dismissed. Sir, this is the background of the case. We are provoked by this order.
You are provoked.
We are provoked by this order.
Who is provoked?
Myself. The contents of the order have provoked. Because on the basis of this, we were forced to issue a notice to the respondent R1 and R2. Sir, kindly refer Annexure A2, sir, page number 13. Our notice is there. This notice, he has not brought to your notice, sir. He has not brought to your notice. Once again, they are misleading. For this, the respondents have replied within 10 days. Within 10 days, they have replied to me. The notice was issued under Interstate River Water Dispute Act 1956 only, under Section 6A3, which allows me to sue the chairman of CWMA.
Nothing to do with the review.
No, one more, sir. To sue the CWMA chairman, or he can sue me reverse if I am wrong in my claims.
He can also sue.
Definitely. But he has not sued.
So let him sue.
Let him sue. I am ready here. I am ready for that. But they have not, I have sued them, but they have not sued me. Instead, they have promptly replied the letter in their letter dated 9/8/24, sir. Annexure A3, page 15. Kindly refer, sir.
So you are learned party in person, but tell the ground of review.
Okay, sir. Sorry, their letter contains all the grounds. And I am arguing only on law and facts. Please give me some patient hearing, sir. Sir, subject letter Annexure A3, page number 15, sir. Subject. They have replied to me. Notice for suing under ISO Deputy Act 1956 under section 6A3 for criminal dereliction of statutory duties and functions of CWMA jurisdiction. They are telling, sir. They are addressing to me, sir. I am directed to say that the Central Government Council in the cases WP number 24288 of 23 and WP 9903 of 2024 in the Honorable High Court of Karnataka, Bangalore, has been intimated why this office letter, even number dated so and so, about the contention raised by you in the notice dated 1/8/2024 regarding the submissions made by the Government Council in the above cases and referred in the judgments pronounced on 17/11/23 and 13/5/24 by the Honorable High Court of Karnataka. They are further telling, sir, in the para second, the Central Government Council in the above cases has been intimated why this office letter of even number 312-315 dated 8/8/2024.
This is their internal thing.
Okay. No, sir. It is repeat to me. It is a turning point, sir. From here, turning point starts. There is a twist in the case from here. There is a twist in the case, sir. I will talk about law also. I will talk about law also. There is a twist in the case.
But if we debar the party in person who is arguing by wearing T-shirt, then
Sir?
if we debar the party in person
Ah.
who argues the case
Hmm.
before the High Court in a very casual dress of wearing a T-shirt, then you are before the High Court.
Yes, sir.
You must be decent in your attire, as you are decent in your submission.
Yes, sir.
Yes, proceed.
Sir.
Proceed, will not grant more time. It
No,
doesn't
sir.
mean that we are.
Sir, sir.
Don't presume that we go on your hearing anything and anything.
Okay, sir.
Yes.
Okay.
Please be relevant.
Okay, sir. What they're telling, the Central Government Council in the above cases has been intimated what is episode. So the CWM has not submitted any written statement or has not filed any affidavit
This has nothing to do with the review.
to the Honorable Court through the Central Government Council in the above court cases.
This,
And the CWM has not submitted any document or written statement or briefing to the court in these cases.
yes.
So they are disowning themselves from whatever observations are recorded in the order
They are
leading to the dismissal.
withdrawing.
Sir?
They are what doing? They are
No,
withdrawing.
no, they are disowning.
Disowning.
They are disowning.
Disowning.
Yeah, disowning whatever submissions made by the government advocates which are recorded in the order. Sir, at this juncture, I want to submit one quotation made by a retired judge, Jail Maida of High Court of Delhi. High Court of Delhi. On the last day of,
You also argue at High Court.
on the last day of his retirement, in his farewell speech, he says a significant quotation, sir. In every court of justice, in any court of justice, both the parties know the truth. But it is the judge who is on trial.
Judge is on trial.
It is the judge who is on trial. That is what he means. That quotation is very much applicable here. Sir.
That's right. When party in person argues, judge is always in trial.
Sir,
because you argue irrelevant. You come on the point.
Sir, I am coming, sir. The central government.
So you said that glaring constitutional discrepancies. Then you referred to paragraph 2 of the order, the read entire order. Then you referred to the order letter containing grounds at page 13 and submitted that this order is a ground of yours to review the order.
Yeah, no, further is there still. Sir, I have to come to the law. Still, I have not come to the law.
Now, last argument.
I have come to the law.
Last, yes.
Sir?
This is last argument.
No, this is their letter. They have not applied law to these submissions. They reply. That is where they are playing, sir. If you apply the law, I am sure you will be convinced of the merit in the case. The central government, in exercise of power conferred by Section 4 of the Interstate River Dispute Act, constituted the Water Dispute Tribunal wide notification so to adjudicate upon the water dispute regarding the interstate river Kaveri and the river valley thereof among the states of Karnataka, Kerala, Tamil Nadu.
You will hear their version also.
Okay, I will hear.
Yes. Now he's saying that this
Lord, I have only one submission.
Please continue.
Only one submission to make. On the previous occasion, when your lordships disposed of the writ petition, very graciously, your lordships exercised restraint from imposition of cost. I don't think that restraint should be exercised this time. I have nothing more to say.
Sir, I am ready for imposition of the penalty. I am ready if you impose a penalty, provided my argument is patiently heard. I am ready for.
We are considering that.
Okay. Sir, para 2, sir. Para 3. The Kaveri Dispute Tribunal.
But we can read, you need not read.
No, sir, I have to apply the law. I am going to apply the law now. The Kaveri Water Dispute Tribunal gave its award in 2007, sir, which was challenged by the party states in the Honorable Supreme Court. The final decision of the award was published in 2013 on the directions of the Honorable Supreme Court. However, the dispute was under adjudication in the Honorable Supreme Court. Sir, kindly, now I am coming to the application of law, sir. Sir, kindly refer page number 18, Annexure A4.
Page number?
18, Annexure A4.
Yes.
The matter was in the Supreme Court.
Yes.
And the matter in the next para they are telling, sir, kindly refer back page, sir. Para 4. The award was modified by the Honorable Supreme Court, void its order dated 16/2/2018, and for implementation of the award, Kaveri Water Management Authority and Kaveri Water Committee were constituted in June 2018, which are now functioning. CWMA and CWRC, they are now functioning. Sir, further statement is very crucial, sir. That he is not telling, sir. I am taking very serious objection for that.
Yes, yes.
In the same paragraph, he is telling the CWDT, Kaveri Water Dispute Tribunal, was dissolved in July 2018. This matter they have suppressed before this court, sir. Kaveri Tribunal, in the order dated 31/5/24, it is recorded that the tribunal has already been functioning since decades. Tribunal is decade, it is working. Kaveri Tribunal is still working. So I have come to the High Court wrongly. That is the observation made there. But the chairman has admitted the Kaveri Dispute Tribunal was dissolved in July 2018. Sir, kindly refer Annexure A4, sir. Annexure A4, page number 22, sir. Annexure A4, page number 22. Under the Interstate River Water Dispute Act, Clause 12, dissolution of tribunal, that is the heading, sir, dissolution of the tribunal. The central government shall dissolve the tribunal after it has forwarded its report, and as soon as the central government is satisfied that no further reference to the tribunal in the matter of would be necessary. This Kaveri Water Tribunal was dissolved as admitted by the respondent 2 in 2018, sir. This matter they have not brought to your court, sir. They have not brought it to your knowledge. Kaveri Tribunal is not at all functioning since last 6 years. That's why I came to this High Court.
Yes.
Clause 12, page number 22, sir. Annexure A4. The Kaveri Water Tribunal is not in existence since last 6 years. But it is record, they have told, submitted before the court that Kaveri Tribunal is still functioning since decades. It is not so. This is suppression of fact. Under the Interstate River Water Dispute Act, the tribunal was lawfully dissolved. It is not at all functioning since last 6 years, sir. That is as per the clause 12. Next, sir. Is page Annexure A3, page 16, sir. Back to that. Their reply. The award was modified by the Honorable Supreme Court, void its order dated 16/2/2008. And okay. Next, sir. Once the judgment has been given, in the last paragraph, they are admitting once again. Therefore, it would be factually correct to say that the Kaveri Water Dispute Tribunal has given its award, which was subsequently modified the Honorable Supreme Court, quite it the order date 16/2/2018. After that only gazette notification is issued. And for implementation of the award, CWMA, CWC were constituted in 2018. Once again, he is emphasizing the Kaveri Water Dispute was dissolved in the July 2000 once again. Sir, now, one false statement they have to admit now. It is wrong. They have suppressed the fact before this court. Because Kaveri Tribunal is not there, I have no other alternative. I have come before this High Court. There is nothing wrong on my part. Sir, next. Very crucial, sir. They are telling this Honorable High Court has no jurisdiction to intervene in this matter. Sir, kindly refer Interstate Water Dispute Act, Annexure A4, page 19, sir. Page 19. What clause 6 says? Clause 6. Publication of decision of tribunal. The central government shall publish the decision of the tribunal in the official gazette, and the decision shall be final and binding on the parties to the dispute and shall be given effect by them. The Kaveri Tribunal report is binding on all the parties. Sir, next, clause 6/2. It is very, very crucial, sir. The decision of the tribunal after its publication in the official gazette by the central government under subsection 1 shall have the same force as an order or decree from the Supreme Court. The Kaveri Tribunal is equal to the Supreme Court order. That is what River Water Dispute Act says, clause 6/2. So, this clause empowers this High Court to uphold the Constitution, sir.
We have heard you. We'll proceed.
Interstate River Water Dispute Act.
We'll proceed with order after recess. Arguments are over.
Number 37.
So IA number. IA number 2 of
2 of 24.
2 of 24.
Yeah.
In writ petition number 9903 of 2024. This
Sir, my submissions are not over. My submissions are not over.
not over, but our order has started.
Sir, my submissions are not over, sir. There is one more crucial evidence I have to submit.
We will take how much time?
Only 5 minutes.
5 minutes.
Only 5 minutes. Sir, one mail is referred to the Ministry of Water Resources. Ministry of Water Resources. Ministry of Water Resources, central government, referring the matter to central government Solicitor General, Mr. Tushar Mehta. We have sent a mail to him.
We do not.
No, okay. That mail, a copy is sent to Mr.
We don't take such notices.
Yes, sure. No. So there, all these points which they are not answering, they are opposing Interstate River Water Dispute Act. Now, from what we are seeing.
Don't take any notice of any mail from anything, from any quarter, from anywhere. We stick to the pleadings. Yes.
Sir,
If
okay.
you
Then,
are able
okay, sir, I want to conclude, my sir. I want to conclude. Sir, please, sir, Anagir A3, page 15, sir. The reply of the chairman. So in their letter, they have admitted that Kaveri Tribunal is dissolved. It is not existing anymore since last six years. They have admitted. And they have also admitted that the Supreme Court has settled the matter. So that under Article 131 and 141, it is binding on all without question. And under clause 6162 of the Interstate Water Dispute Act, the Kaveri Tribunal is binding on all. And it is having the same effect as the Supreme Court judgment, as per 6/2. So, as per the clause 6.1, they have not published the 3 prayers we have requested, A, B, C. They have not published it in the Gazette notification, sir. They are supposed to publish. They are in the report. The recommendations of the report, tribunal, they are in the Kaveri Tribunal report, but they have not published it in the official Gazette. That is a major discrepancy, sir. What is recommended by the tribunal, if they are not making part of the Gazette notification, sir, what we have to think, sir? They have to make it part of the Gazette. That's what we are requesting. Make them a part of the Gazette notification under clause 6.1 and 6.2. And they have not disputed our any of the allegations in our notice. They, in fact, they have surrendered to our notice. My only request is, please uphold 6.1, 6.2 of the Interstate Water Dispute Act, and according to that, whatever prayers we have asked for, they may be implemented and enforced by publishing the Gazette notifications. That's all. What we wanted, they are already in the Kaveri report. I am not asking for Moon and Mars. Sir, one more thing. Finally, sir, Anajir A3, page 15, page 16, sir. 16. Last paragraph, page 16, Anajir A3. The Central Government Council has been accordingly requested that the above position may kindly be brought to the notice of the Honorable Court in the above cases. But they have not brought anything to the notice of this court. And whatever points of law under the Interstate Water Dispute Act, namely 6/1 6/2 and clause 12, dissolution of the tribunal. They are in the content of my notice. Sir, finally, I want to read our notice, sir. I will read my notice and I'll close. Sir, Annexure A2, page 13. Copy, addressed to Chairman, Kaveri Water Management Authority, New Delhi. Sir, provoked by your actions, decisions to conceal and suppress the following statutory rules, sections under Interstate River Water Dispute Act, 1956, under Article 262 of the Constitution, before the Honorable Karnataka High Court in WP number 242 of 23, CCCC number 131 of 24, and WP number 9903 of 2024, to obtain court orders by fraud. This notice for suing your office is issued under section 6A3 to meet the ends of justice. In the order dated 17/11/23 in WP number 242 of 23, you have concealed and suppressed the government notification dated 16/7/2018 regarding lawful dissolution of the Kaveri Tribunal under section 12, resulting in miscarriage of justice, preventing the High Court from passing a lawful favorable order under Article 227 of the Constitution to rectify the glaring error apparent on the face of the record in the tribunal verdict at clause 9, admitted in the court as recorded in its order dated 17/11/23 under Code of Civil Procedures, Order 8, Rules 3451. Next, the Honorable Karnataka High Court had no jurisdiction to decline indulgence in this matter in view of the section 6(1), 6(2), and 9A data bank, which cannot be a secret document being a public document. You have made a false statement before the High Court that the Kaveri Tribunal is still functioning since decades, but which is not under section 12 after its dissolution. Point 3. You have misrepresented that the matter in the PIL is a currently running river dispute, which is not, as the dispute is constitutionally settled by the Honorable Supreme Court by its order dated 16/7/2018, as admitted in the dispute, is constitutionally settled by the, as admitted in the government notification dated 16/7/2018, which is binding on all under Article 131 and 140 of the Constitution, which cannot be questioned by any High Court.
That is all.
Final, sir. Regarding this point also it is coming. You have misrepresented the section 11 out of context in WP number 9903 of 2024, which has become redundant in view of the section 6/1, 6/2 of the ISRWT Act, which says that the decision of the tribunal is final and binding on all and have the same force as an order of decree of the Supreme Court after its publication in the official gazette by the government of India. Sir, what I am appealing to this court, sir, kindly in the 75th year of constitutional celebration, we shall not violate the Constitution.
So
we want, please direct them to uphold the Interstate River Dispute Act clause 6(1), 6(2) and publish the missing recommendations of the tribunal as part of the gazette notification, which is required under 6/2, sir. That's all, sir. And one more case is pending in the court of Mr. Dixit on the same matter. It may come up after another 2 weeks. Same matter is not there also.
Interim application number 2 of 24 in writ petition number 9903 of 2024. Displayed by filing this interim application in the writ petition, which was already disposed of on 31st May 2024, is to recall and review the said order dated 31/5/24, whereby the writ petition, which was styled as public interest petition, came to be dismissed by the court for the reasons recorded in the order. Full stop. recollecting the prayers as advanced in the original public interest petition. Full stop. The petitioner wanted the court to direct the respondents to enforce the national water policy, public water allocation priorities. In the distress year, it was further prayed to enforce the release of water. It was further prayed to direct the authorities to release the water from Mettur Dam for source Mettur Dam for Samba, SAMB, Samba crop during the August, September, January, February. It was next prayed to facilitate the growing of minimum one crop by farmers of the two states. Full stop. While dismissing the petition as a misconceived public interest litigation, this court noted the submission made by submission made on behalf of the respondent authorities that the prayers in the petition would, if at all liable to be considered, would at the best fall in the realm of the jurisdiction of the tribunal, and that the subject matter was not fit to be entertained and considered in the public interest jurisdiction. Accepting the said submission, the court also noted in the order that earlier writ petition number 24288 of 23 was filed on the same lines and in relation to the same subject matter, which was not entertained by the coordinate bench as per order dated 17/11/23. Not only that, full stop. Not only that, against the said order dated 17/11/23, contempt petition was filed, which was also dismissed. Observing further that the petition as filed and as thought to be furthered was an abuse of process of law, seeking review paragraph of the said order. A learned party in person invited attention of the court to the grounds raised in the memorandum of interim application for interim application, wherein the prayer for recalling and review is made. The court considered the said grounds. उसके learned party in person का name लिखना सब starting. What is your good name?
Manjunath.
Manjunath.
Manjunath K.
Further, learned party in person thereafter submitted that the order under review suffers from glaring constitutional discrepancies. He referred to paragraph 2 of the order and reiterated the submission. Full stop. Learned party in person was permitted to read the whole order in order to enable him to demonstrate as to what was the error on the face of the record of the said order. Full stop. Learned party in person thereafter invited attention of the court to the communication dated email communication dated September 2024. After reading the contents thereof, it was submitted by learned party in person that what is conveyed by the said email to the authorities are also pressed as ground for review of this petition. He thereafter showed to the court communication from the Kaveri Water Regulation Committee dated 9/8/24, addressed to the President of the Jagrut Karnataka Jagrutha Bharata, who is the petitioner, who is the petitioner party in person herein, in which the details about the functioning and the discontinuance of the Kaveri Water Dispute Tribunal are stated. On the other hand, paragraph learned additional Solicitor General of India for Karnataka, Mr. Arvind Kamath, assisted by learned additional
Deputy.
Assistant Solicitor General, Mr. Shanti Bhushan, submitted that the review petition is not only misconceived, but is an aggravated form of abuse of processful law. It was highlighted that supporting the order under review, it was highlighted that the court had already observed in the said order that the public interest petition itself was a misuse of process of law. It is tried principle that the review jurisdiction could be entertained only in the event where the order suffers from an error apparent on the face of the record. Full stop. The error on the face of the error apparent on the face of the record is such error which could be noticed at the first blush and at the first glance, and which does not require any elaborate arguments. Although the court permitted the party in person to make submissions at his own pleasant length. In Kamlesh Verma paragraph, the host of the party in person could not point out as to what was the error apparent on the face of the record of the order dated 31st May 24, whereby the public petition was dismissed. Full stop. In Kamlesh Verma paragraph versus Mayawati and others, 2013 8 SCC 330 320, the Supreme Court has summarized the principles relating to the exercise of review jurisdiction by the court. Full stop. It is well settled that the review jurisdiction cannot be converted into appellate jurisdiction, the review petitioner cannot be permitted to re-argue the case. Repetition of old and overruled argument is not enough to reopen the case. Discovery of new review is not maintainable unless the material error manifest on the face of the order undermines its soundness, or that the order has resulted into miscarriage of justice. Full stop. The review is not an appeal in disguise, and the arguments cannot be repeated in the review jurisdiction, nor it is a ground to review that a particular argument was omitted from being canvassed in the original proceedings. Full stop. While dismissing the thoroughly misconceived interim application for recalling of the order, the court appreciates the submission on part of the respondent advanced by learned additional Solicitor General that this review proceedings is a process, abuse of process of law in repeat, full stop. It is true that party in person was unwarrantedly insistive and he proceeded to unduly emphasize irrelevant aspects of the matter, and that his vehemence was higher in degree, even higher in degree than what was shown while arguing the main matter. Notwithstanding, this court is inclined to show the greater grace and leniency to the party in person for the simple reason that it cannot be presumed that the party in person, sir, are well versed and committed to the discipline and decorum of the court proceedings. The petition is dismissed. The interim application for recalling is dismissed as meritless.
Sir, interstate recovery order dispute, that only we are asking for, sir. Implementation, total implementation of the every clause.
Grateful. Okay.
Lordship, serial number 66.
Yes.
R1 and R3 are the government officials, and for others I have taken
Which
steps.
matter?
Serial number 66. Please.
60?
66. 66.
Six.
Yes, your Lordship.
So what do you want?
I complied the all objections.
Complied with.
Yes, your Lordship.
That is PIL again.
No, your Lordship. Serial number 66.
Which matter? 56. So
R1 and R3 I have are the government officials, your Lordship, and for others I have already taken the steps. Yesterday I have taken the steps, your Lordship. Please to adjourn the matter.
when do you want?
Any convenience of this honorable court, your Lordship.
18th of February, as requested by learned advocate for the petition.
Much obliged.
Crossover matters, seal number 11. The contempt to Srikanth MP. To Srikanth MP.
Learned advocate for the petitioner was present in both the calls. The contempt petition could have been dismissed for want of prosecution. However, in the larger interest of justice, it may be listed on 10th February.
Number 16. To Shekhar L. Writ appeal, fresh writ appeal.
16.
16.
Same order. Writ appeal could have been dismissed, but keep it on 22nd January.
Seal number 18. Mr. Vinay
Appearing for
Pippal.
appearing for appellant, my lordship. In this matter,
Yes.
fresh election has been conducted, my lordship. We need to amend the prayer. Kindly have it on next week.
It will give a fresh cause of action. So elections are conducted subsequently.
Yes, my lordship. For the
Tuesday.
post of president, we have challenged the caste certificate.
Pardon?
My lordship, we have challenged the caste certificate, my lordship, cancellation of caste certificate. Now they have elected the president post elections, my lordship. Some pleadings has to be inserted. Kindly have it on next week, my lordship.
You passed it. Yes, it is. Madam, we are disposing of, although we may reserve liberty for you if permitted in law to institute a fresh proceedings.
Rashmi, I am the member of the Jaglur Gram Panchayati Malarship, and that membership I have selected as a president, holding the president post. Now the membership has been cancelled. Due to that, the presidentship also cancelled. Fresh election has been conducted to president post. Hence, kindly have it 2 days time, maybe, my lordship. I will complete the pleadings.
No, we are.
My lord, this writ appeal is concerning a writ petition filed by me. There are 2 writ appeals.
This appeal came to be preferred by, they came to be preferred against judgment, common judgment and order dated 3rd July 2024. Insofar as it is related to the decision in writ petition number 668 of 2019. The appellant herein was the original petitioner who had challenged order dated 15/12/18 passed by respondent number 1 assistant commissioner, whereby the caste certificate of the petitioner came to be cancelled. The reason for paragraph cancellation, the grounds of cancellation were highlighted by learned single judge in paragraph 17 of the order to be as under. So quote paragraph 17. As a result, a writ of quo warranto was after quoting. As a result, the writ of quo warranto was issued by learned single judge, and the petition was dismissed. The other petition was allowed, and the petitioner thereof was consequently not retro, don't read writ of quo warranto. Consequently, after quoting paragraph 17, consequentially, the writ petition of the appellant petitioner was dismissed. The other petition, which was filed by the elected candidate, was allowed by learned single judge.
My lordship, one submission. My petition has been dismissed. Their petition, defeated candidate petition has been allowed. We have challenged both the writ petitions. Another writ appeal is pending.
The other petition of the candidate was allowed, and a writ of quo warranto was issued, removing the respondent in the said petition, namely the petitioner hearing, appellant hearing, removing him from the post of the councillor of ward number 9, Jagalur Town Municipality. Post of today, when the petition came up for consideration, appeal came up for consideration, learned advocate Mr. So-and-so for respondent number.
Respondent number 5, my lord.
Who is 5?
Is a petitioner in this in writ petition. Was a petitioner.
There's the petitioner in the other writ petition.
In
a memo to place on record the subsequent developments. The memo indicates that subsequent to the order passed by learned single judge, removing the appellant from the office of the councillor of the town municipality, the seat of the councillor fell vacant and the by-election was conducted on 23/11/24. The results is also declared, and once the Adarsh has been elected to the said post as councillor. Full stop. In view of the above, the said memo dated 8/1/25 paragraphs taken on record. In view of these developments, the subject matter become infectious. The appeal is liable to be dismissed on this count only. Full stop. If any grievance survives for the petitioner in any respect in relation to subject matter, comma, it will give a fresh cause of action to the petitioner in accordance with law, which may be and the appellant is permitted an appellant is liberty to institute independent proceedings as may be permissible in law in accordance with law. Dismissed as the appeal is dismissed as infructuous. Next.
Bill number 32. D. Nagaraj.
Lords, I am for the petitioner, my lords. I pray for adjournment, my lord.
It is over now. This is also over.
My lords, any short of, please, my lord.
Why?
Personal inconvenience with senior. Senior has some personal inconvenience, my lords. Any short, next week.
You are there. You are there. And you look like senior.
I will learn, my lord. I will learn and come, my lord, please.
You are not senior, but you are learned now. Tomorrow at 2:30.
Bill number 38. To Vinod Kumar M.
Petitioner.
I appear for
My
the
lord, they have
leading applicant in this matter, my lords.
My lord,
I filed an IA seeking to implead in the said writ petition, my lords.
There was a direction 31st July 2024. Lord, I pray for some time to comply with that order because I have not received it from the DC, my lord.
Some statue is erected.
Yes.
Yes, my lords.
Who's doing?
The impleading applicant, my lords, is a society registered under the Karnataka Societies Registration Act. The statue, my lords, is erected by the impleading applicant, and whereas it is erected in the site belonging to the society itself, my lords. So for that reason, my lords, we are necessary.
Sale deed is, what is this sale deed?
Sale deed is, my lords,
On whose
executed by the fourth respondent on behalf of the governor to the society, my lord. That is the impleading applicant.
So the statue is already erected.
Yes, my lords, this is erected with the taking due permissions from the authorities.
So statue, you find out what is it? Learned additional government advocate. Srimati Akbar wants to take instructions put up on 10th February.
my lord, interim order may be.
Interim order is it? What is the interim order?
Interim order not to put up further continue.
It's already constructed and inauguration is also completed.
That is, but it is closed now.
It is already erected.
Yes, my lords. And inauguration function, I have produced the
Inauguration.
photos also.
That is, however, my lord, there is interim order not to.
Only interim order we can pass if the respondent shall not
Continuation.
infuse life in the statue. No other interim order. Statue is already there, standing. Interim order is what is the, let us see, what is the interim order? It is, let it go. It continues. Interim order, faster days will continue to till the next.
Number 39. To Mahesh.
Appearing for the complainant, my lord. My lord, the contempt petition itself becomes infructuous because the accused herein has preferred a writ petition and there is a stay which is operating. So in view of the same, the contempt petition will become infructuous, my lord.
You are
So
for
it may be,
complaint, You are for
Yes, my lord.
complaint?
Yes, my
Learned
lord.
advocate. What is your good name? Miss so and so for the complaint is stated.
Miss Usha S. Nair.
Usha so and so that the present proceedings have become infructuous as the stage obtained by the other side in the writ appeal.
Yes, my lord. The writ appeal number is writ petition, my lord.
Any of the
Writ
statement,
petition
the
number is
petition is disposed of as
23970.
infructuous. The parties shall abide. Appeal is preferred.
No, my lord.
No, my lord.
In writ petition, interim order has been obtained, your lordship.
Writ
Therefore, in writ petition,
In writ petition.
not in writ appeal.
the order is obtained. The, as per the state, in view of the statement, the contempt petition is disposed of as not surviving.
Yes.
My lord, can I also ask for a liberty if a fresh cause of action is
The
occurred?
parties shall comply with the, parties shall abide by the orders which may be passed in the competent legal proceedings. Whereafter a fresh cause of action, if any, may arise for, not necessary.
No, not necessary, my lord. It will lead to another problem.
Correct.
Yes.
Much obliged, my lord.
Deeply obliged.
Seal number 40, A. Madhusudan Rao.
Lords, this matter, I pray for some time, my lords.
Learned additional government advocate will promote the litigation 6 times, stand over to 10th March.
Obliged.
My lords, an earlier date perhaps, my lords, an earlier date, my lords.
10th February.
My lords, may I make one submission? 10th March would be,
Why?
My lords,
that's in this matter, my lords.
Holding.
No, my lords, this is issuance of Sagoli check. There are about 150 cases of this sort. Forest, tree rights have to be decided and Supreme Court judgment will be coming in our way. So we'll have.
my lords, there are 2 writ petitions that we have filed, my lords. In 2013, we have filed 1 writ petition. In 2022, we filed 1 writ petition.
Kindly
All
grant me
clearances have been given and considerations have been made by the Honorable High Court back in 2022 itself.
obliged.
All little 18th February.
Obliged.
Obliged, my lords.
Clear.
Number 41, 42 are urgent. Seal number 43, Mr. Naveed Amar.
The complaint plots.
My lord, in this case, my lord, the writ petition, my writ petition, the writ petition filed by the corporation has been dismissed, my lord. He's seeking disobedience of the order or in the past in the writ petition, my lord, and against which a writ appeal has been filed, my lord. That is 1432 of 2024.
Lords, they filed the writ petition, lords not moving it before the court and not lords complying the order.
And he has also filed an execution petition before the principal city civil judge, my lord, in 2642 of
No,
2020.
that is separate, my lord. That is not.
Seeking non-implementation of
Your
the.
writ appeal is coming up when?
My lord, it is posted today, my lord. The only office objection is, my lord, that I have to serve him copy of the appeal memorandum, my lord. Otherwise, even in the first, the only.
Yes, any date, it can be clubbed along with the not writ appeal, my lord.
Which is the number, serial number?
My lord,
Not before, lord.
my lord, before the registrar, my lord.
Register.
Yes, my lord. It was posted today before the registrar.
Stated in respect of the order brought under the contempt jurisdiction in this proceedings from a writ appeal number 1432 of 2024 is filed. And that only office objection therein is the non-supply of the copy of the appeal to the petitioner, to the caveator.
To the
caveator, full stop. Learned advocate, paragraph may so and so appearing for the respondent appellant. You are for workman.
Lords, I'm lords labor, lords.
Together. Learned Advocate Mr. So-and-so stated that the copy shall be supplied to the
Yes.
petitioner herein within 3 days?
Yes.
Within 3 days. To stop the paid writ appeal number so-and-so, as well as the present contempt proceedings shall be listed on 21st.
Public notes.
On 22nd of January.
Public.
On 21st, my lord.
21st.
Public.
21st. But what is the contempt, Mr.?
Lords, they have not complied, Lord, the finding of this court, Lords. Lords, I sought, Lords, for light work, Lords.
No. For contempt, there must be direction. What is the direction?
Lords, it is my application, Lords, to reinstate me under section, Lords.
For that, where is the direction of learned single?
Lord, there is a direction, Lords, I will establish, Lords.
No, what is the established? There is nothing to be established. It is only black and white.
Lords,
In contempt, there is no color.
Lords,
Except black and white.
Lords, 2 more orders on the IS, Lords, that I will produce it before the court, Lords.
But
Lords, on 22nd, 21st, I will produce it, those 2 orders, Lords. Orders on IS, Lords, filed by me, Lords.
So, it will be easier on 22nd.
Lord.
Where is the direction?
There is a direction, Lords.
Read
Let them say, Lord, there is no such direction, Lord. There is a direction, Lords, to consider and give the right duty, and also, Lords, to.
Where is that?
Lords, it is not here, Lords. I will produce it before the court, Lords.
No, order must be here, order under contempt.
Lords, the orders passed on IA is not here in this, in the contempt petition. Orders passed on IA. IA is not, Lords, writ petition is filed by the Lords respondent.
Contempt is.
I filed IA, Lords, in the same writ petition. Lord, there are 2 orders on the IS filed by me, Lords. I will produce those IS, orders on IS, Lords.
That IA order would merge once the order, this petition.
No, Lords, 17B application filed by me during the pendency of the petition. Lord, they were supposed, Lords, they are statutorily, they are bound to give, Lords, the 17B wages. That they have not given, Lords. Thereafter, Lords, I filed IA. IA was allowed. Lord, during the pendency of the petition, Lord.
In any case, you need to annex this order with your contempt petition.
I will annex, Lords.
So this contempt petition is not validly filed.
That's I will produce those IS along with the orders, Lords, along with an IAM, Lords.
No. That is not done. Strike out the earlier order.
Lords, kindly see, Lords, if they are not complying, Lords, the order of this court under passed under section 17B of the Act, Lords.
Where is the order on record?
I will produce it, Lords. I will produce
it. Means what? This is incomplete filing of contempt petition. On that they will dismiss on that ground only, unless you file afresh.
I will, Lords. In advance, I will produce it.
Not permit you to substitute.
I will, Lords.
Correct. So right now we'll dismiss.
Lords, I will produce those orders, Lords. I will show it to the court, Lords, on those, Lords, the orders passed on those IS. Your Lordship.
No, showing will not do. It has to be on record.
Lords, I will produce it.
How your petition could be cleared for out of office objection when there is no order under contempt is produced along with the petition.
I'm sorry, I will produce it, Lords.
Next.
Number 44. Mr. Madanagowda.
Appear for compliance in this case, Your Lordship.
I'm appearing for the respondent number 2. May permit me to file a compliance affidavit.
Pardon?
Compliance affidavit, I permit me to file a compliance affidavit.
Learned Advocate Mr. So-and-so wants to file compliance affidavit. Stand over to
One
11
submission, Your Lordship.
February.
One
You are filing?
submission.
I'm filing compliance affidavit, my lord.
What is directed?
Direction by the single judge, Your Lordship, is to continue the complaints in the same place, Your Lordship. They are working as a teachers in the Muraj Desai residential schools, Your Lordship. I'm audible, Your Lordship.
Para 6 of your affidavit, my lord.
So you are working now.
Please, my lord. My lord, in spite of the order of the single judge, my lord, they reviewed me on August.
Services of petitioners, teachers, lecturers, till regular recruitment is conducted.
Please, my lord.
So nothing will survive now. They are working.
Please, my lord.
They are in
Lord,
service.
my submission is, Your Lordship. On August 5, my lord, they relieved us, your lordship. And since
Pardon?
from then, my lord, from August 5, 2024, your lordship, they relieved us. And till my lord, till January 5, my lord, without being any salary to me, my lord, I have kept outside your lordship. In spite there is being directions not to relieve me, my lord, they have relieved me in August 5, my lord. There is no salary, my lord. There is no source of income for the teachers, your lordship. Since from August, your lordship.
You are paid, you are paying salary or not?
My lord, you are paying the salary, my lord.
No, my lord. Since from August, there is no salary, my lord. They have relieved on August, your lordship.
Only they have
Now,
challenged.
when the notice is issued by this honorable court, my lord, they have complied and they have taken back me to on duty, your lordship.
They have taken you back in service.
Please, my lord, please, my lord.
That's right. So that is the only direction in this.
Only direction is to not to relieve the complainants, my lord. You are not, therefore, you have taken back the service.
They have relieved on August itself, your lordship.
That doesn't mean that you should not pay the salary.
No, my lord, you are paying the salary because the complainants are the temporary employees, my lord. For the reason is, my lord, we have permanent employee, we have placed it in the.
So continue in service, continue the services means includes
please
payment of salary.
We are paying, my lord.
So you are paying.
Yes, my lord.
No, my lord, they have not paid.
Please record this.
From August, please, my lord. It may be taken on record, your lordship.
So we will record it and dispose of it.
Please, my lord.
Through agency, they are collecting the
Not paid,
payment
my lord,
through
let them
agency,
pay
my lord.
from, let them pay the
All the
salary.
complainants are the outsourced employees, my lord.
How many petitioners are there? Or several petitions are there?
There are several petitioners, but only they have come to this court only for 5 members before this court complaint.
Contempt is filed in all or one of the petitions?
My lord?
Is contempt released to which petition?
Only 5. Only 5 members, my lord.
Only?
Only 5 complainants.
Relatable to which writ petition? This contempt?
Writ petition number 7047.
7047. Where is that?
It's page number 8, my lord.
First one. All right. How many petitions? 5.
5 complainants.
This contempt proceedings arose from common judgment and order dated 21st February 24, passed by a single judge and group of disposing of group of petitions. Comment so far as the decision related to number 7047 of 2023, in which there are 5 petitioners in all. Paragraph. Learned single judge directed the respondents to continue the services of the petitioners as teachers, public lecturers, till regular recruitment is conducted in accordance with the Karnataka Residential Educational Institutions Society into bracket, cadre and recruitment, bracket over, and second bracket amendment, bracket over, regulations 2021. The contempt petition was filed for the alleged non-compliance of the said direction by stating that the petitioners were discontinued from service despite the direction to continue them in service. Today, paragraph, when the proceedings come up for consideration, honored advocate so and so files compliance affidavit 88-125, in which it is stated inter-alia that respondent has taken steps to withdraw the earlier transfer orders and that the petitioners are accommodated and they are in service. They are continuing in service. Full stop. When learned advocate of the petitioners, learned petitioner could not dispute the factum that the petitions have been permitted to be in service and that they are continuing in service. Full stop. However, he sought to submit that salary is not being paid. Full stop. In this regard, learned advocate for the respondent asserted that all the petitioners are paid regular salary by the respondents. Full stop. In the aforesaid view, comma, nothing survives in this.
Since from August, your lordship, they have not paid the salary, my lord. They
Proceedings are
relieved me on
liable
August,
to
your
be-
lordship.
liable to be, the proceedings are not liable to be continued. Full stop. The contempt petition is dismissed. Full stop. It goes without saying that continuing the petitioners in service would include payment of salary. If the salary is not paid, it will give cause of action to the petitioner to enforce their right in accordance with law.
Please. Serial number 49 also has a similar matter, your lordship.
49 also similar.
49 also similar.
Which one?
49, serial number
49. Similar.
Similar.
So identical order. will-
Identical order.
Identical order, 49.
Grateful.
Number 45, TP Vivekanand.
For the complaint.
My lords, I appear for the accused in this matter, my lords. I appear for the accused in this matter, my lords. We have complied the single judge's order, my lords, except for cost and the interest, my lords, for which we have preferred writ appeal, which is pending for consideration, my lords. So I pray that writ appeal may be tagged along with this and be heard together, my lords.
Let's
We have partly complied, my lords. For cost and interest, we have preferred and writ appeal, my lords.
Who is industry?
Accused, my lords. KPTCL.
KPTCL
Yes,
is
my
not
lords.
treatable.
Yes, my lords.
May I submit minutes?
Yes.
May I make a submission minutes? The direction issued by the learned single judge is to pay this arrears of salary from 38/2002 to 36/2011, page 20 of the order minutes. That next direction, my lord, is the KPTCL shall also accord promotion to the petitioner that he was entitled to during the period between 38/2002 to 36/2011. The KPTCL shall also accordingly fix the pay scale and pay to the petitioner his pension on that basis. As a result of the refixation of pay scale and pension, the arrears shall be paid to the petitioner within a period of 2 months from the date of receipt of the copy of this order. But the next portion of the order is for payment of interest, and para 24 is for respect to payment of cost. But they have preferred writ appeal only against the direction contained in para 23 and 24. But insofar as direction contained in para 20, they have complied. They have paid the arrears of salary from 38/2002 to 36/2011. The directions contained in para 21 and 22 are not yet complied with, minutes. They have not complied with, the direction contained in para 21 and 22.
This arrears are paid.
Arrears are paid. The notional promotion is not granted, and the difference of pay scale on grant of notional promotion is not paid.
That they have preferred.
No, not to that extent. They have preferred writ appeal only insofar as the awarding of interest at 8% and imposition of cost of rupees 50,000.
Yes,
Only to those two directions they have preferred writ appeal.
my lords,
Therefore, there
we-
is no compliance as such.
Is it so?
My lords, we have preferred and writ appeal for the, as he said, for cost and the interest, my lords.
Then-
But we have complied the rest of the order, my lords.
Let them file
We may be
affidavit,
placing
my
it
lord.
on record, my lords. I may be allowed to,
Let
give
them
1
file an
week's time to
affidavit.
file compliance affidavit.
them-
my lords.
let
We'll
them-
be stating all the details. my
Now
lords.
he is saying that all directions are complied. Complied with. Promotion is
lords.
granted.
My
my
instructions are that we have
It is
complied,
not-
my lords. We'll be placing it on record, my lords. I may be allowed.
Let them
week's
file
time,
an
my lords.
affidavit to the effect that they have granted promotion and paid the
Respond.
difference of salary.
Respondent KI KPTCL wants to file the compliance affidavit. Time is granted, stand over to 5th of February.
Grateful, my lords.
Please.
Writ appeal is coming up when?
My lords, it is not yet come up before this honorable court, my lords.
Writ appeal number is 724 of 2024.
No, my lords, not yet, my lords.
It was
is
listed
before the
before the-
registry, my lords.
No. There is listed before this court or other bench.
No, my lords, this court, my lords, the division bench. But office objections are yet to be complied, my lords. We'll be complying it soon. If my
It was
lord
listed
permits,
before
it
the-
may be tagged along, my lords. I may be allowed to give the writ appeal number, my lords.
Learned single judge imposed some cost.
Yes,
Yes,
my
sir.
lords.
40,000.
50,000.
Writ appeal number
724 of 2024, my lords.
724/2024, which is filed against the order under contempt. shall be listed along with the present contempt petition. Office objections, if any, shall be complied with.
Yes, my lords.
Before the next.
Grateful. my
In
lords.
the writ appeal.
Please.
This number 46, HP H.
But in this matter, writ appeal has been preferred and notice has been issued, my lords. It is listed on 28/1/2024.
As the
My lord,
contempt is already subjected to writ appeal and writ appeal wherein notice is received returnable on
28/1/2024.
125, this
my lord,
contempt petition
I've
shall be
been, not
listed
been served with the copy.
along with the writ appeal on the same day.
Kindly tag this,
To be considered simultaneously.
please.
Like,
873.
47.
873 of 20.
Complainant.
Of 2024.
Prayer for the accused, my lords, we have complied with the learned single judge's order. A compliance affidavit of the same effect has been filed before this honorable court as well as served before my learned advocate.
Please, my lord. They have
learned
complained.
advocate for the petitioner, Miss so and so, as well as learned advocate of the respondent, Miss so and so stated the order under contempt is complied with. This statement of fact could not be disputed by learned advocate for the petitioner, Miss so and so. In the aforesaid view, nothing survives in the present proceedings. The contempt petition is dismissed as
Fine
not
may be imposed, my
survived.
lord. Fine may be imposed, my lord. 10 months, no salary for the complainant, my lord, and the break of service also, my lord.
You will share the fine. Then will impose. Next.
Please, my lords.
This is number 48. AM Muni Krishna.
Yes, 48.
Time for the complaint, my lord.
Compliance affidavit has been filed, my lords.
Did not obey this honorable court order, respondent, my lord. Simply
This is
issued the
with
endorsement.
124 endorsement is filed. What
Please.
is the endorsement?
Lords, in the endorsement, we state that when we went to conduct the Podi and Durasti, the complainant is not in possession of the land. There is somebody else in possession of the land. And they have raised objection and disputed and not allowed to conduct the survey and Podi.
But then you reject the reprise application. Reject, it is reject. It's not rejected. That's
We have not rejected, my lords. We have said that let them resolve the dispute and thereafter we will conduct the survey and Podi.
Kindly permit me to file the counter affidavit, my lord. We are in possession. And kindly permit me to file the counter affidavit. I did not, respondent did not obey the court order and filed simply.
All that is stated
Surrender.
is consider the representation, my lords. Tahsildar is directed to consider the application which would be filed by the petitioner and do the needful as expeditiously as possible, at any rate within 2 months. Lords, your lordship, kindly see paragraph 3, where we have put in efforts to conduct the Podi and Durasti.
My lord.
what reply can be filed?
My lord, all documents is standing in my name and farmer 1 to 5 also prepared. We are in possession. We have sufficient document. We are the original grantee. Which objection given to the one Shantamma raised by Kyantamma? She is the purchaser of block number 14. I am filed application for conducting Podi Duras work in block number 11.
So in the petition, you claim that the land belongs to you.
Oh, yes, my lord.
So then now it is otherwise found. You could take your own remedies. Contempt will not serve.
Please.
My lord, this honorable court passed the order in WP number 5 double 10,511 of 24. It clearly.
Bring forward a case before learn a single judge that the land bearing survey number 11 oblique B11/P1, which was a Kushki agricultural land at measuring 19 gutas at Tammenahalli village, Chennaraya Patna, Hubli, Devanahalli Taluka, was owned by the petitioner. A prayer was made to direct the respondent authorities to consider the representation for carrying out the survey, 4D, and durest work of the said land. Full stop. Learned a single judge directed the respondent Tehsildar to consider the application of the petitioner in that regard and do the needful as expeditiously possible within stipulated time. It is the above direction which became subject matter of contempt for their alleged non-compliance in the present proceedings. Full stop. In response to paragraph notice issued by this court, comma, the compliance affidavit is filed by respondent by the respondent Tehsildar, in which is inter-alia an endorsement dated 9/4/97/24 is produced. Herein it was stated that the authorities proceeded to carry out the 4D and durest work. However, the property was found to be in possession of another person named Srimati Santhamma, widow of.
My lord, she is the owner of the block number 14. She is the purchaser. I have the original grantee of the block number 11. That is she illegally one rowdy sheeter raised by the objection and colluded with the respondent. They issued this type of endorsement.
Santhamma, widow of late Ramaya. Full stop. The order oblique endorsement highlights the aspects which emerged on factual verification in the following words. I'm extracting from the endorsement at page 6. This flag on the verification of the grant of enjoyment of the property. It was further recorded in the endorsement that even before the order was passed, or even before the order of the High Court, request memorandum dated 7/12/22 was given, which was verified, and it was found that the Assistant Director of Land Records, Devanahalli Taluka, had visited the place with other officers on 19/6/24, and a spot inspection was carried out in presence of said Srimati Santhamma. It is rightly recorded that the dispute deserves to be settled by the parties by approaching civil court. Full stop. In the above facts and circumstances emerging, it is not possible for the court to conclude that any of the respondents have committed any contempt of court, much less a willful contempt, to maintain, so as to permit the petitioner to maintain the present contempt proceedings against them. The contempt proceedings are disposed of. The contempt petition is dismissed. 40. Next.
Post, number 50.
Please, Your Lordship. Your Lordship, in this petition, the direction was that the petitioner shall be entitled to access and use all the lab facilities in the university as it was before. My lord, all the lab facilities have been denied to me now for 1.5 years.
I'm just filing the reply, my lord. In fact,
There is no specific direction, my lord, which they alleged to have been disobeyed by us. There is no, my lord, there is no, absolutely there is no disobedience of any order, my lord. All the facilities, my lord, all the lab facilities has been extended to them. Because undertaking was given, it has been extended to them. Then, my lord, again, my lord, they are simply making an allegations against the university.
My lord,
and
it's
the
not
dean and
correct,
all,
my lord. It's
saying
not
that, my
correct.
lord, let me finish.
My lord, all the wires, my lord, I have been, last hearing, your lordship will remember, there were 200 isolates.
Yes.
Because it is a biochemistry PhD. And there were several isolates bought from the government agencies. And on 6th, they opened the refrigerator, the deep freezer. Nothing was found there. It cannot be a compliance, my lord. It is all missing. All the isolate which was kept in the deep freezer and those which was bought from the Pune government agencies, not a single item was in the deep freezer, my lord. That cannot be. All missing. I am also filing what I found there.
May I make one submission? Management is
My lord, somebody is doing mischief against us. Some action requires to be done. Not a single item of those was found in this deep freezer. Because the order was you have to facilitate. My lord, it was under the custody of one of the professors who kept it locked from May 2023. And after the petition was filed, he continued and removed everything from the deep freezer.
Even if you read what we can do, how to implement this direction?
My lord,
how do we undertake the inquiry?
My lord, your lordship take my representation against what they are saying, and just only one page I will show to your lordship what they did.
May I make one
My lord, what I am praying is, my lord, action must be taken to those who have made these isolates disappear.
You are doing PhD.
Yes.
PhD guide.
PhD in microbiology, my lord. 3 years I went to the forest, I collected all the isolate, and now
PhD guide is already changed.
Yes.
PhD guide.
And the allegation.
No, one of the previous
Not
guide.
only against guide, my lord,
No,
against
no,
vice chancellor,
they were
registrar,
asking,
everybody, my lord, there are a lot of complaints.
That earlier guide was asking all kind of favors. But when it will reach a limit, I said, no, I cannot. Action must be taken, my lord. My lord, if none of the isolate I purchased and kept 200 of them, not a single one in that deep freezer. I have bought by way of affidavit, I am giving evidence, my lord.
My lord, what happened, my lord? Last date of hearing, my lord, my learned senior friend has said there are about 200 isolates which was there, then they were not allowed. Then, my lord, what university did, my lord, because there are a lot of allegations which is being made by the student, my lord, against all the officials of the university, guide, vice chancellor, registrar, everybody. Then, my lord, a notice was issued to all of them who have kept everything, my lord, in the deep freezer and refrigerator. And in the presence of the petitioner, a merger was drawn and she was asked to identify or whatever the articles.
My lord, kindly take page 10 of this affidavit, my lord.
And a proceedings was drawn. Proceedings was drawn. Whatever is available, 110 isolates were there. It was given, handed over to her. She has acknowledged it. She cannot claim the 200. There is no document.
My lord, kindly take page 10.
To show that, my lord, she has kept 200 isolates. 110 was there and she has acknowledged it has been given. Then, my lord, in order to avoid the further complications, she has been given a separate refrigerator and almirah, and we are asked to keep all her my lord, isolates to that almirah, and keys has been handed over to her. That also she has acknowledged. And
Yes,
she's unnecessarily
yes,
making
my lord,
allegations against
they
the
want,
university
they are pressurizing me to withdraw all the complaint, and because I am not doing it, they are doing all this and destroying my career. I have filed complaint, that is correct, but they are pressurizing me. My lord, kindly see page 10 of what I have given. There is only one deep freezer and and the chairman asked her to open it. It is all in the custody of that particular professor. And kindly see the next para. Mrs. Harsha Tejaswini has claimed that no boxes were found related to her isolate microbial cultures in the deep freezer, my lord. Not a single piece out of 200 which I collected during the 1.5 to 2 years, and those which are purchased. You remember, your lordship, earlier I had mentioned we purchased it from Pune, and that has to be in the deep freezer only, because the moment you remove it, my lord, kindly see page 9 also of what I submitted. Page 9. Page 9 of my submission. And 4 of them were found outside the deep freezer. It is reported, my lord. 4 of those which I purchased from the Pune was found taken away from the deep freezer. And that is mentioned here in the middle of the page, refrigeration number 1. Whenever they want to just destroy my career, I cannot do PhD. Now I have to repeat all those. And what the direction was just to facilitate and to deny everything. Everything they removed from the, even these isolates are, my lord, then the deep freezer has to be kept. I purchased it from the Pune laboratory.
Lord, whatever she has purchased, bills are produced, it was identified and she has taken back. That is the proceedings.
No, not in the deep freezer. No, please.
They
It
cannot
is not
make
in the
false
deep
allegation
freezer.
before this court, my lord.
It is taken out of the deep freezer, 4 of them. The remaining 200, we don't know where it is. My lord, some action must be taken, that person who is responsible to do all this. And if that is done, my lord, I will not press the contempt petition.
My lord, this
Because
exercise
it
was
is
done
total destruction of my career.
This exercise was done, my lord, because your lordship has last date of hearing, a memo was filed saying that 200 isolates is not found. In fact, there is if your lordship, my lord, see the direction issued by the single judge, my lord, there is absolutely no contempt at all.
But you are harassing this.
My lord, if I am to say, there are police complaints have been lodged against the vice chancellor, registrar evaluation, dean, chairman, and SC/ST commission complaints have been, Lokaयुcta complaint has been lodged, state women's commission complaints have been, about 8 complaints have been every day, my lord. It's an habit.
Just because
And
I'm
it is
making
very
complaint,
difficult to administrate the university.
do these kind of things, my lord? This is most unprofessional.
It's a very old university, and my lord, there was not even a single complaint, my lord, against this university all these years, my lord. It is more than 100 years old university, my lord. We do not know. We do not have any grudge against anybody, my lord.
No, it's not correct, my lord.
And at the request, we have changed the guide also. And we are given all the facilities. Simply, my lord, but filing a petition and making wrong allegations, going and giving complaint to the police. We are not every day, my lord. There is an harassment for these officials, my lord, who are in the administration.
My lord,
What's the direction, my lord?
Any teacher with some responsibility will not do what has been done to me today.
Any student
1.5 years, 1.5 years hard work.
She will not do all these type of things.
1.5 years of hard work, collecting isolate, purchasing it from government agencies, keeping it in the deep freezer. Now, when it is opened after 6 months of the court order, she was refusing to open it.
Oh, no.
And after 6 months of the court order, when it is opened, there is nothing in the deep freezer. That is at page 10 I have mentioned.
Lord, I do not know, my lord, why these submissions are made. Please see, my lord, the proceedings which has been recorded. My lord, all these things have been videographed because we know, my lord, what type of candidate is this. Everything has been videographed and pen drive also has been produced. Whatever the bills she has produced, those articles were there, she has taken.
My lord, I have repeated that
Lord,
also.
Let not make a false submission, my lord.
Kindly see page 12 also.
Your student, you are not permitted.
I know, my lord, my student, but for one student, my lord, is ruining the entire university, my lord. That's what we are really finding it very difficult Vice Chancellor and Registrar, they are not able to do anything. Every day, my lord, there are complaints. Now, how can, how Vice Chancellor, Registrar and other evaluation are, my lord, concerned with all these things?
My lord, Vice
Clearly, because there
Chancellor,
is a,
Vice Chancellor was
yes,
gracious enough.
see, all these allegations have been making against Vice Chancellor. How he is concerned with one student who is doing some PhD,
Vice
my lord, in
Chancellor was
microbiology?
gracious enough to constitute a committee. Now the chairman forced her on 6 to open this. I have mentioned it in page 12 also. Kindly see.
Document number
The
one, my lord.
access was denied since July 2023. And page 12, para 3, kindly see.
How can we enforce this? And there is a word against word.
Yes, my lord.
There is a word against word. You are saying that they are not permitted you the access to the facility.
Yes, it is, the report itself shows, my lord.
And they are saying that we are permitting.
That's right. But that is what the report itself.
Which report?
Which I am submitting is a report only, part of the report. Kindly see, the report begins at page 8. And I'm reading part of the report. Kindly see page 12. This is the report that I have said they are complying. Kindly see also page 12, 10 and 12. 10 I read earlier. In the 12, kindly see para 3 in the middle of it. More than 200 isolates of mine preserved in 1 ml vial and kept in deep freezer was not found in the deep freezer. But few of 1 ml vials kept in the deep freezer was found in the refrigerator. That once you remove it from the deep freezer, we cannot use it. It loses all its viability and they are not in working condition. No teacher of any professional contact will do this. Just remove those 1.5 years work I did and thereafter kept it in the deep freezer because I made complaint. Complaint was for different thing that is going on in a different level. But that has nothing to do with this, destroying my career. Your Lordship may kindly.
What happened to these 200 isolates?
Lord, 110 was found, it was given to her. Please see, Lord, I am just reading the proceedings. Yes.
This is
She has
proceeding
taken,
only.
she has acknowledged, I had put the documents. That's what I am making. Your Lordship may kindly see my reply today I have filed. Page 7 may kindly be seen. This is the proceedings.
Of today's.
Yes, my lord. Page 7, the last paragraph, my lord. The committee was constituted. Then, my lord, we are all the research scholars, my lord, were asked to be present before because everybody has to keep it in the same laboratory, including this student. Then, my lord, it was merger was taken place and they were asked to identify their isolates and their articles. Everybody has identified. She has also identified and is taken. My lord, I read the last paragraph, my lord. Page 7, my lord. In the research laboratory allotted to Professor Shubha Gopal for her research work, Research Lab 5A, Department of Studies, Microbiology, University of Mysore, a total 4 number of all members are present. Page 7, of...
My lord, they called 4 former research people who finished their PhD and gone, just to make a crowd of it.
Lord, let me read.
It was not relevant at all to call the 4 former research research scholars. Just to show off that we are calling everybody, see what is in the deep freezer. But as far as I am concerned, there was nothing in the deep freezer. That is, in this report, my lord, the same report what he has submitted, kindly come to page 10. He has reproduced it. Page 10.
My lord, management said for past 1.5 years, she was not allowed. Please read the page number 8, my lord, the first. The bills which for just to purchase, bill number so-and-so, HIV number 1, which has been handed over on 4/11/23. She has taken. In all the things, refrigerator and freezer, whatever her things, it has been handed over to her, she has taken.
His own report at page 9 and page 10 say there was nothing in the deep freezer.
Page 12 may kindly be seen, my lord. It is what has been handed over, what has been given.
Now, when she places certain things in the deep freezer.
Yes, there will be no documents will be there.
No documents will be there.
Yes, whatever it's for students, my lord, to go there and do whatever they want to do. And the progress report, they have to come and tell the my lord, give it to the guide who, my lord, verifies and
My lord,
tells
there
that
is a
they have done
record.
anything or not.
You don't have any security.
No, there is a record.
No, you don't have.
I
any
had
sec-
given it last time. There is a record.
Any
where it-
cameras or anything saying that who meddles with all those things like?
No,
to
my lord, it's
verify?
not there. My lord,
My lord, there is a record. I
complaint.
have submitted it earlier. In the previous hearing, it was submitted. That record say at page 5 of the what I submitted that these are to be kept in the deep freezer. This is the bill which I paid to the Pune, and the Pune supplied it with the instruction that they should be kept in deep freezer. And how to open it, how to carefully use it, all are here. I have given all the records here. Now they cannot say there is no record. My lord, it is called active culture. There is a page 10 of my previous submission. It's called active culture, freeze-dried cultures.
No guide will
And
go
they are
enter the
giving
app.
no guidance are here. It is in my submission. All the guidance were there.
No guide, my lord, will enter the lab. Only the students were allowed, and they themselves they are allowed. That's why, my lord, we have called everybody who has kept it
Yes,
there.
but in this case, she kept the deep freezer locked and
That is
kept
totally
the key
false,
with
madam.
herself. And that was opened now by the committee on 6th only, after 1.5 years. It is she herself who destroyed it, my lord. I can state on the at the bar.
My lord, she's
My
not a
lord,
guide for her.
this is the height of something a teacher can do to a student, whatever be the reason. You remove the isolate which you buy with the instruction that it should not be removed carefully. There are 10 instructions how to remove those from the deep freezer. I have given this in the previous submission, and they just take it out and throw it out.
Lord, on what
And
basis they are making allegations?
other 200 isolate not found anywhere. They are only given something. Well, would you keep it in an almirah, taking it from the isolate from a deep freezer? That is what they have done. They kept it in an almirah. Well, this is the height of disrespect to her own profession, my lord.
Lord, after having changed the guide,
Your
my lord,
lordship may direct.
but again make
the-
an allegation against the previous guide, all these allegations.
My humble submission is your lordship may direct the vice chancellor to take action as per this report and in accordance with the report only. And I will withdraw the contempt petition. I'm not interested. I'm interested only in PhD. Now I cannot do it. I'm out of it.
No. May I read the proceedings, my lord, where she has taken and all the things? Lord, page number 8, my lord. Mrs. Asha Tejasvi has claimed the following, the 3 bills for the chemicals and glasswares. Page 8 of my reply, my lord, today what I have filed. Number 1, bill number 1 ME so-and-so, which has been handed over to her during 4/11/2023. My lord, this has been, she herself has taken on 4/11/2023. Now a submission is being made for past 1.5 years. I've been not allowed to go inside the laboratory. It's totally false. All these types of allegations she is making everywhere, my lord. And next number 2, my lord. Bill number 2, so-and-so, which has been handed over during the meeting on 6/1/25. Day for yesterday, madam, on Monday, my lord, just been handed over to her. What she has produced, what she has kept it there after purchasing it. Next, bill number 3. This also, my lord, which has been handed over to her. It was available there and handed over to her. Mr. Arsha Tejasvi has acknowledged the above for having received the articles. Other research scholars identified the items and kept it back in the almirah. Next, there were 2 refrigerators maintained by Professor Shubha Gopal, laboratory, research lab number 5A, so-and-so, to store and maintain the microbial culture and isolates. These 2 refrigerators were opened All the research scholars and Mrs. Harsha Tejasvi were asked to identify and authentic the cultures, chemicals, and isolates. In refrigerator number 1, Mrs. Harsha Tejasvi found that the following.
No, these all
cultures
were not
occurred.
isolates, my lord. They were not the isolates.
I'm asking the
Kindly
matter-
see page 9. Page 9 and 10. He said there was nothing in the deep freezer.
Heard learned advocate, senior advocate, Mr. So-and-so for the petitioner, this complainant, and learned advocate. What is your good name?
Rajendra Kumar Sanghi. I'm accused, madam.
Anant Kumar.
Rajendra Kumar Sanghi.
Rajendra Kumar for the respondent. Petitioner herein has been undergoing her doctoral work for PhD in microbiology under the Mysore University respondent to hearing. Writ petition came to be filed by the petitioner. Out of the grievance where the petitioner had sought permission for change of guide for his PhD studies. While disposing of the petition, on a single judge, inter-alia, issued the following direction, which has become subject matter of alleged non-compliance and contempt of court. So court B, page 19.
And page 10 of his report. Para 3.
Submissions there.
Page 10, para 3. And the second para in page 9. In his own report.
Directions are this.
Yes. Direction.
Yes, my lord. Page 9 in his report say, Ms. Harsha Tejaswini claimed that no boxes were found in relation to her isolates. That is there in second para in his own report. Para 9, page 9, second para. And page 10.
While disposing of the petition on 14th June 20. The contempt of court has been alleged by the petitioner on the premise inter-alia that so the direction is to entitle the petitioner to access and use the laboratory facilities in course of the studies, she is denied the access to such facilities which he was using earlier. It is the case that the keys of the deep freezer and almirahs have not been given to the petitioner complainant despite the court's order. It is further stated that isolates from different sources, microbial growth media and other chemicals.
Microbial cultures and cryopreserved cultures.
Total 200 in numbers, costing lakhs of rupees. Are kept in deep freezer.
And kept with a lock and key.
And that they are kept in lock and key, which are again not parted with by the respondents. In course of the submissions, Adjournment, senior advocate for the petitioner, elaborated his grievance and such facts of missing isolates from the deep freezer. In response to the contempt proceedings paragraph, reply is filed by the registrar of the university, in which the correctness of the claim of the petitioner is denied.
Hundred and 12 isolates has been handed over to her. She has acknowledged. I said in para 5.
But from the Almera, not from the deep freezer.
It was stated in the affidavit inter-alia thus: the quote from paragraph 5, page 2, pursuant pursuant to the said direction, the university in order to ascertain. कहाँ से लेके?
There are 6 also, my lord, I have said.
Cultures and chemicals. Paragraph. It was stated that proceedings were video recorded.
Yes.
And the students who were present, including the complainant, signed the recorded proceedings. It is also stated that at the time of Mahazar, the cultures, chemicals, and isolates were those which were reflected in the bills produced by the complainant, showing the purchase thereof. By detailed evidence, respondent university denied the allegations of the petitioner that she is not permitted access to the facilities, or that the isolates were not allowed access, or that they are missing. Noted that the respondents have produced
Copy of the report begins from page 7.
copy of the meeting
Proceedings of the meeting held on 6/1/25.
of the Department of Studies, Board of the Department of Studies, held on 6/1/25. Following is recorded.
And deep freezer was opened at page 10.
That is this. In the research laboratory allotted to Professor Shubha Gopal, वहाँ से start bracket for.
And the para begins, the second para. He says there was no box in the deep freezer. It is their own report, my lord.
6/1/25. It was stated that petitioner acknowledged the receipt of the above articles. It was further stated that 2 refrigerators were maintained by Professor Shubha Gopal to maintain the microbial culture in isolates.
My lord, also para 12, the page 12.
The other isolate details of the isolates, petriples and petri plates, which were found in the other refrigerator by the petitioner, who acknowledged the receipt of the same. It is also stated in the minutes that the other research scholars identified the isolates, cultures, chemicals, and articles, and same were kept back in the refrigerator for the use. But
Page 12. And in his report, page 10.
Say of the petitioner that the box is not found. It was further stated that one deep freezer was maintained by the professor at the laboratory. Which was opened with the permission. And the petitioner was asked to identify and confirm the articles. According to this, the petitioner claimed that no boxes were found related to her isolation. One research scholar, however, could identify the articles and same were kept back in the deep freezer for further use. With the aforesaid submissions and the factual assertions, it was contended by the respondents that no contempt is committed. Full stop. The controversy unfolds to a state of things where there is a word against word. On one hand, the petition contends that certain isolates or cultures were put by her in the deep freezer, whereas the said fact is denied by the other side, and the minutes of
No
the
matter
board of
those
meeting
kept by us is by some other
was recorded,
not mine.
was recorded as reproduced herein. Full stop. The issues raised by the parties involve highly disputed questions of fact. It is one of the serious area of dispute to whether the petitioner had put his isolates in the deep freezer or not, and whether if put, they were missed. Whether if they were put, whether they went missing because of the conduct of the respondents. From these aspects are the aspects which need the factual inquiry. Evidence is required to be laid. Full stop. It is not possible, paragraph, for the court to hold, in the presence in such circumstances, any of the respondents or officers of the university to be guilty of contempt of court, much less willful contempt. Full stop. The petitioner may have its own remedy, which would be other than the contempt proceedings. May have other remedy to assert and enforce her rights. However, the contempt could not be alleged, since could not be alleged in view of the could not be alleged and could not be established in view of the above facts highlighted by the full stop. In the aforesaid view, there is no substance in the contempt present petition. It is dismissed.
Much obliged.
So number 51, Mr. Dev Prasad Shetty.
I appear for the appellant's counsel. The order at Annexure E, page 74, translated copy, page 74. Initiating an inquiry under Section 64 of the Cooperative Societies Act was under challenge, on the ground that this is something that has been done on a direction issued by the Honorable Minister at that point of time. Your Lordship may kindly see page 63. Page 63, Annexure D, translated copy at page 64.
Now, in the petition, you did not challenge this order,
I challenged it.
or you challenged the note by the minister.
Not the note, my lord. On the basis of this note, an order was passed that was challenged.
That was challenged.
Please, your lordship may kindly see the note, my lord. Second para, page 64.
Single judge dismissed the petition.
Learned single judge dismissed the petition saying, yes, there is a direction, but anyway, even other material is also considered, therefore there is application of mind. But my respectful submission is, your lordship may kindly see.
Where is the note of the minister? It is on record. Note of the minister is on record.
Yes, my lord, page 64.
Page 64.
63, it is in Kannada, translation page 64. Second para. In the said letter, it has been stated regarding irregularities taking place in Karnataka State College lecturers and so House Building Cooperative Society, Mysore, and requested to undertake inquiry under section 64 of the Cooperative Societies Act. Hence, it has been instructed to undertake inquiry under section 64 of Cooperative Societies Act as per his request. This is addressed to the joint register. Lordship may kindly see what I've said. Section 64. The registrar may, of his own motion, by himself.
We admit this and finally decide it.
Please.
Full stop. This appeal is directed against judgment and order dated 1st February 24, passed in common in 3 writ petitions, whereby on a single judge dismissed the petition.
That order is already stayed in another writ petition. Now we have given complaint. We the members have given
The
complaint.
challenge in the petition, the challenge in the original petition
Then
was
on our complaint, now an inquiry is held by the
with the order passed. Where is that order? 64.
Annexure E.
Page, you just showed us.
The one which your lordships now saw was page 64.
No, not 64.
Please, my lord, the order is at annexure E. Kindly see reference number 3, directly relying on this.
Page.
Page 74.
Order passed by the additional registrar of cooperative societies, whereby the inquiry.
may make impugned order.
Under
The
section 64 of
petition, there is an order.
Cooperative Societies Act 1959. Full stop. The main plank of paragraph challenge, people on a single judge, was that the inquiry under section 64 of the Act was conducted by the authority pursuant to and influenced by a note. Page
64.
Page 6, note by the cooperative minister, note dated 23/3/21, sent by the cooperative minister, requiring the authority to, instructing the authority to undertake the inquiry under section 64 of the Act in course of assailing the impugned judgment and order of law on a single judge, whereby the writ petition was dismissed, and the challenge to the inquiry order of the authority was negative from a learned advocate for the petitioner, Mr. So-and-so, senior advocate so-and-so, invited attention of the court to section 64 of the Act. Full stop. The section provides that the registrar may, of his own motion, by himself or by person authorized by him, by order in writing, hold an inquiry into any matter specified in the order touching the constitution, working, and the financial condition of a cooperative society.
May make the submission
It could be
with
submitted
court permission.
by learned
There are 3 writ petitions. This minister's direction is challenging one writ petition. Earlier, there was one more writ petition by him. Now on our complaint, now one more inquiry which are under section 64, 68. Then court says, I will para 15 of the learned judges order for a moment kindly be looked at. May I read, my lord? Admittedly, in this case, the registrar in terms of impugned annexure C has referred to two complaints before the passing of the order. The impugned order also refers to note forwarded by the Minister for Cooperation. However, in overall consideration of the contents of the annexure E, it is very much apparent that the registrar has not acted at the instance of the Minister for Cooperation, to whose note he has referred. On reading of annexure E, it is appropriate that registrar has summarized the contents of the complaint referred to the said order at annexure E. The very fact that the registrar has summoned the complaint against the society would indicate that the registrar has applied his mind and prima facie satisfied that there is a need for inquiry. What he has done is, he has not given sites to the members. Third party, he has given non-members. He has given 50 crores to his brother-in-law to go abroad. That apart, even contractor has said that he has not paid the amount.
My learned friend has filed an application for impleading. He is not a party.
Let me complete. He has not paid them. In my first applicant has been given the site in the lot. He has paid full amount. Then he has not initiated a given site. Then he complained to assistant registrar. He has given direction to allot site to the first applicant. He challenged in the writ petition. In spite of the writ petition being dismissed.
It is right and well settled that a statutory authority exercising his powers and discretion under statutory provision is expected to function independently, and his discretion and exercise of powers should remain uninfluenced by the external force or the guidance of any other authority, much less a political authority. Full stop. In that view, section 64 would require the registrar, when he exercises the powers, to hold inquiry either on his own motion or upon other material or application, to
May I make one more request?
Exercising its own independent discretion. Full stop. In the facts of the present case,
May I make one more request, my lord? Let the inquiry, whatever so far has happened, be submitted to the court.
Prima facie concluded that the registrar has been influenced by the said note and without and forsaking his own discretion, which is statutorily required to be exercised independently, has proceeded to conduct inquiry under section 64 of the Act. Paragraph. A strong prima facie case is made out. The decision of learned single judge dismissing the petition requires detailed examination. Therefore, the appeal is admitted. It shall be heard. It shall be listed for final hearing on 25th March.
I had the benefit of an interim order during the pendency of the writ petition, my lord. Your lordship may kindly grant the interim order.
May I make this submission?
What was the interim order?
The further proceedings of the inquiry
There will
was
be no
taken.
further proceedings pursuant to the report of the registrar.
Independent. Further proceedings after inquiry
will not permit any such things.
One more request. In my impleading application, some ranking difference in wakalat, it may be currently be condoned. In my impleading application, the members who had, there is some wakalat ranking doesn't tally. All the wakalat are there, 1, 2, 3, wakalat 1, 2.
You file or whatever.
I tally it.
Next. Delay is condoned.
Please.
How much delay? Delay condoned. First, the present application is filed for condoning delay of 107 days. Having heard learned counsel for the parties and having perused the supporting affidavit in which the passage of time is explained, from it could be said that there is no element of negligence or culpability. Full stop. No litigant would while away the time for the sake of whiling away when he wants to litigate for his rights in the circumstances and for the reasons supplied in the affidavit. Sufficient cause is made out.
My application is formally allowed so that I can file objection.
Then the order in appeal. Yes, next.
Number 52, Sagar V. Shastri.
Please, Your Lordship.
My lords, in serial number 52, writ appeal bearing 1166 of 24, I take notice for R3 to R10. I seek time from the Honorable Court to file my wakalats and place my statement of objections on record, my lords.
You notice. What is the matter?
Lord, the order passed by the single judge, my lord, with regard to the promotions of
Promotion. Notice to the respondents written about.
already, my lord, they have been served. My learned friend is
Learned advocate Miss so and so appears and wants to file wakalatnama. Time is granted. The appeal shall stand over to 21st February.
Please, my lords.
Blythe.
Number 53. Faisal Sherwani.
For the respondent number one in this matter, my lord. An interim order was granted by this honorable court of stay of this order. They have filed an application to vacate that interim order, my lord. May I be permitted 2 weeks' time to file our objections?
Sure.
Learned,
Lordship, one objection.
Yeah, Chinnappa wants to file.
Objections to his application to vacate the interim order.
Application which is filed by the respondent.
Respondent
to
number
vacate
one.
the interim order. Time is granted. Stand over to which date?
One submission.
Lordship may.
28th of January.
Very well. As a matter of fact, this main matter itself can be heard. If my learned friend has no objection, we can hear your lordship may hear the.
No point in.
So, Your Lordship, there's one memo that I would like to file. One objection was raised on my IA number.
What is the matter?
Lord, this is a matter, my lord, under the Prevention of Sexual Harassment at Workplace Act. The issue, my lord, was whether a cab driver, if he commits an sexual misconduct inside the cab, would that become, in this case,
Previous to previous.
whether he'll be subjected to a workplace?
Which bench admitted this?
Beg your pardon, my lord?
Which bench admitted?
The vacation bench.
The vacation bench it granted the interim.
Earlier,
Earlier, my lord.
this vacation.
Not this vacation, previous vacation.
What is the memo? It's just. So, my board.
So that's only that.
For the time being, we'll postpone the.
Very well.
I got a submission to make, my lord.
There
The state has also filed a writ appeal, my lord. In WA number 1827 of 24. Matter may be connected along with that, my lord. 1827 of 2024, my lord. The state government has also filed an appeal challenging the same
By
import.
learned senior advocate Mr. Dhyan Chinnappa for the appellant seeks time to file reply to the application filed by the other side to vacate the interim relief from a learned additional government builder stated that another connected writ appeal number
1840, my lord, I'm sorry. 1840 of 2024.
1840 of 2024 is required to be placed together, required to be heard together in the aforesaid view.
My learned friend, Lord, as my learned friend says, he'd rather argue the main matter itself. Lord should fix a date for hearing itself.
Sure. I have no objections to that.
Even as the respondent has filed interim application for vacating the interim leave, today when the this proceedings came up for consideration, learned advocate Mr. So and so stated that it would be appropriate that the main petition itself, main appeal itself is heard. In that view, the interim order granted earlier stands confirmed. The appeal shall be listed for hearing on little longer. 17th March.
Okay.
Full stop. Learned advocate, correct, learned advocate,
Lordship.
Haris submitted that connected writ appeal number 1840 of 24 should be listed together.
Please.
It is ordered accordingly.
Great.
Lordship, any date in February if possible, because the stay is now, it's been 3 months.
February, a small month of 28.
Wait.
Smallest month of the year, yes.
It's number 54.
Here for the petitioners, my lord.
Delay.
The matter has to be heard, my lord. The government has filed a memo that may be rejected and may be posted for final hearing, my lord.
Why?
My lord,
What is this? 2017 PI. Ambedkar University, you must have done something. No?
My lord, before that, my lord, may please take paragraph 2 of the writ petition, my lord. It has to be dismissed on that ground alone.
Paragraph?
2. Description is given with regard to the first petitioner. My lord gets it.
Yes.
My lord, the last 2 lines from the bottom of that paragraph, the said amendment has come into force from 25/2/2016. She is aggrieved by the impugned action of the respondent in interfering with the operation of the statute and divesting the authority of Gram Sabha in the matter of so and so. It's a personal interest and not a public interest.
How?
My lord, she says she is aggrieved, the first petitioner.
None.
There are 2 petitioners. My lord may see. Paragraph 2.
Maybe read from the beginning, my lord.
Yes, yes.
So is aggrieved as public interest petitioner, not?
Yes, this is a public interest litigation. She cannot be personally aggrieved.
He is not personally aggrieved. How can you read that?
My lord, first paragraph, second, very well.
He is aggrieved because she is in capacity of public interest petitioner aggrieved.
Very well. Speak.
And there must be a substance because this is pending since 2007.
No, my lord, since it's come up after a long time, my lord may grant me some time to find out what is the situation, my lord.
Find out. Learned additional government advocate wants to take instructions since the petition is coming up after long time. Stand over to 27th of February,
Obliged.
Much obliged.
but doesn't survive anything.
It does, my lord.
Nothing survives.
It does, my lord, because of the annexure A, my lords.
I'll verify it, my lord.
Much obliged.
December 55, Mr. K. Arjun Verma. 55, the PIL.
Live. To be listed on 16th of January. In view the fact that the presence of learned record of the learned of the parties was awaited in vain. Next.
Madhusudan GR, 56.
Respondent number 6.
Yes. What is it about?
With 100% violation without obtaining plan approved from BPMC. So they are seeking for demolition of this building within a specified time.
It was early.
Mr. Ken Puttagoda still appears for BBMP? It doesn't appear. We order notice some advocates, BBMP standing counsel.
In 56, it was stated at the bar that learned counsel who appeared earlier for the Bangalore Mahanagarapalika has not been in active practice. Now, in that view, it will be fitness of the things that the notice is issued to the respondent Bangalore Nagarpalika, returnable on 18th March in order to enable the Mahanagarpalika to make alternative arrangement.
Here also the same thing. 2 to 4.
In 55 also same order. Whereas loan advocate Mr. K.N. Puttegada appeared
Puttegowda.
on behalf of responder R2 and R4. Same order. You are for petitioner?
No, in this case, 57.
Acha, the registry shall, since the learned advocate petitioner is absent, registry shall take steps to serve the present order upon the respondent, Brother Bangalore Mahanagar Palika.
My lords, in serial number 57, I appear for the second respondent, my lords. An interim report was submitted. I seek time and objections were raised. I seek time to file the final report of the completion of work before this honorable court.
Relating to?
Regarding the completion of the public toilets to be.
May I submit, this is my case. This is a public interest litigation filed regarding not proper maintenance of the public toilets in the city of Bangalore. Then this honorable court.
The schools, no, city of Bangalore.
In the city of Bangalore, then this honorable court expanded the scope to the entire state and called upon the government also to file the report. That has not been done. That's what the cause list says. Then so far as the filing is concerned, it was filed in the year 2020, by which they, at that time, the PIL rules of 2018 was not being filed. Therefore, I filed an IA, and therefore the compliance with the PIL rules may be dispensed with. The writ petition was filed, pleadings are complete. The matter has to be, was heard also, for some time, detailed orders are passed.
So what is to be dispensed with?
The compliance with the PIL rules of 2018, it was filed in 2020, At that time, the PIL rules was not being followed, with this honorable.
The office objection regarding compliance of the PIL rules of 2018.
2018.
18.
18,
Is dispensed.
Please, sir. And then they had to comply with the orders of this honorable court.
So and so wants to bear it up. So and so for?
For R2, my lords.
Respondent 2, raise for time to file.
File the final report and the completion of the work, my lords.
Final report showing the completion of work.
Please, my lords. Of the maintenance of the public toilets, my lords.
Renovation.
Maintenance. Please, my
of the public toilets in the city of Bangalore.
And the government also to file the
The
report.
subject matter of the present.
Government also has to file the report.
The reply shall also be filed by, you will be filing, madam?
On 6/4/2023.
Why you are taking dispensation of?
We had to file the entire petition again, that's the reason.
Yes.
On 6th April 2023, there is a direction of the government
You
to file
need
the
to
report.
file some reply here. Consider it, yes.
Please.
When shall we keep?
1 month's time, my lords.
1 month time. 28 February.
Please, my lords.
Please.
Number 58.
Appear for the petitioner, my lords, in this matter. Matter pertains to construction of a stadium in a playground, my lords, in HSR layout.
We'll hold a test match. Why you are filing PA?
My lords, because
Interested in cricket or not?
we are interested in cricket, my lords, but we sought because it was under green zone and it was for playground for people.
But this is for a cricket match.
My lords, it's a cricket match playground.
Stadium is free. Then,
Yes, my lord.
Then why do you file such PA?
My lords, people want also to play football, my lords, sometimes. That's
What
all.
is? What is the prayer letters?
My lords, in 2023, my lords, this court had directed the ADLR report, my lords, from BBMP to see whether they have complied with the guidelines or not, my lords. And that ADLR report has not yet been filed, my lords.
This stadium is now have come up,
Yes, my lord.
constructed.
Instructed, my lord. I'm sorry, my lord. Mr. Srinidhi was on record in this matter, my lord. Mr. Srinidhi was record in this matter.
Who is on record?
Mr. Srinidhi was on record, my lord. As he's expired, my lord. We have come on record. We have seek instructions in this matter and make a submission.
But this is a stadium in this Bangalore.
Yes, my lord. They've already filed an objection. But a memo has also been.
It's very old.
Government. ADLR was appointed as the court commissioner over here. The dispute involves whether the area under construction is less than 5% or above 5%. A survey was required to be conducted and a report had to be submitted. That settles the issue.
That will answer entire controversy.
Now, what happened that? Because on 29/11/22, this order was passed.
Yes, my lord. 13/8/21, my lord, there's a memo filed. The then council. They say, my lord, it was only 3.96 of the total area. May I pass on this?
The report is submitted by Courtroom.
No, my lords.
Why? Not submitted.
Not submitted. There is no report submitted. It's only on the short point, my lords, whether it's 5% or more than 5%.
So my brother has rightly pinpointed the only controversy. But then court commissioner is not submitted report, 2022. There's no time, next date of hearing. So they are constructing what?
They are constructing a cricket stadium, my lords, with a gallery. Actually, my lords, it is a green buffer zone where playground has to be given for every layout. Now, right now in this layout, what they have done is they are constructing gallery, they are constructing a big stadium, and pursuant to which more than 5% of area has been, according to the rules, my lords.
More than 5% area of which total area?
Of that survey number 65, my lords.
Green.
For that court commissioner. Construction is already being carried out, my lord.
It is a different thing, but it's already carried out. Let's take instance.
Yes.
You also come on record, because learned counsel for the respondent shall take instructions as regard the latest position obtaining in the controversy, including as to whether the court commissioner who was appointed pursuant to order dated 29/11/22 by the court has submitted any report. Stand over to 3rd March.
Obliged.
Earlier. 12th February. 12th February. To be listed at 2/3. Not 2/3. This might not be required to be argued. That is how. If it is required to be argued, then we'll post it on a day. 2/3. Not third, you said earlier. Well. Right.
Published.
Yeah. Time हो गया 5 बजे 5:40. Complete 2-3 minutes.
Cell number 59. To P. Sheshagiri Rao.
What is the subject matter?
My lords, the purpose of the writ petition is already served, my lord. They have issued the notice to the private respondent also. We had sought for writ of mandamus, my lords. The DBMP authorities have issued the notice to the private respondent.
Learned advocate Ms. So-and-so appearing for the petitioner. Invited attention of the court to the prayer made in this public interest petition. Whereby the respondents were sought to be directed to consider the representation of the petitioner and to demolish the illegal structure allegedly put up as per the case of the petitioner. Today, when the petition comes up for consideration, learned advocate for the petitioner stated that the petition is not required to be prosecuted any further in view of the fact that the Nagarpalika,
Please, my lords.
DBMP, Bangalore Nagarpalika has already issued notice, so cause notice
Please, my lords.
to the alleged owner of the illegal structure.
Please, my lords.
Full stop. The petition is disposed of, however, with observation that the so cause notice shall be taken to its logical end in accordance with law. This court has not gone into the merits, nor has expressed any opinion on merits. Petition stands accordingly disposed.
Number 60.
Notes, I appear for petition. I appear for petition, notes. I am not the office objection says notes.
What is it?
They have served the copy.
What is it?
They have served. I'll not go through notes, lots of
copies. We served a copy. We served a copies, Beja. We are
You served the copy. All will put up on 11th February next.
Please,
Number
please.
61. Kariga.
Contempt will not survive, my lords.
Contempt will not.
Not sir.
Learned
I'm
advocate.
filing memo to that effect.
Mr. Chandranath Adiga.
My name is Sangamesh.
Learned advocate Sangam. For
Sangamesh.
learned advocate Chandranath Adiga, for the contempt petitioner stated that contempt does not survive in view of the disposal of writ petition number 12794 of 2020. Full stop, and a memo dated 8/1/25 tendered on record. In that regard, it shall remain on record. The petition is dismissed as not surviving. Yes, next.
Oblige.
Cell number 62. Mr. Girish MK.
62 is contempt. It may go to 4th March. Pardon? Learned advocate to the petitioner shall take steps for service of notice for serving the respondents. Send over to 27th February.
Cell number 63.
Let's appear for the complainants. Let's, number one, there is an impleading application filed. My instructions are copy is not served on a, it's a contempt.
We'll list on 19th of February.
Government advocate can take notice for R2, that's the Tahsildar, my lords. It also shows.
Notice.
My lords, fresh
Notice
steps.
not
it
issued.
says.
Notice is not issued.
Notice returnable on 19th February.
I'm serving the copy.
I
Serving the copy.
Learned additional government advocate Srimati Pramodini Kishan. On whose behalf?
That's-
R2 is, my lords, the Tahsildar. R1 is the state. State they have,
I will take on behalf of R1, my lord.
R1. It is already issued, Mr. Paninda.
Let's,
Notice is already issued.
it says steps again, my lords, fresh process has to be.
Simple yes or to 19th February. Yes.
19 to. Number 64,
Copy served to
the Sumana Naganan.
My respondent for the appellants. And it's pursuant to the order dated 5/12/24, we have served. the
Delay
respondent.
of 77 days.
My lords, will verify in the registry and we'll do the needful, my lords.
What?
We have served the respondents and we have paid the process fee on 9/12/24, my lords.
It is a delay also. Yet to be served, all right. Take, find out 18th February.
Grateful, my lords.
Number 65, Abhishek Malipatil.
My lords, I may be permitted to serve a copy on the standing counsel for respondent number 3, my lords. There is only one standing counsel, my lords. N. Ketty, your lordship.
May I make one submission, Manya? This appeal is directed against the interim order passed in by the learned single judge of this honorable court. Since the matter, writ petition itself is disposed of.
Nothing,
My
sir.
lords, no, my lords, I may be permitted to produce the final order of the writ petition, my lords. In terms of the interim order dated so and so, my lords, the writ petition was disposed of, my lords.
Then this will
Hence, my-
survive in any case.
No, my lords, this is with regard to additional attempt, my lords. Your lordship had permitted to attend 2 subjects, my lords. In terms of the interim
Order,
order,
this order no more survives. In view of the decision, the main writ appeal.
Let's-
This is interim order. So how can appeal be can survive?
based on the interim order, my lords, the final order is given, my lords.
Maybe. So what?
That interim order is the
File
final
again.
order, my lords.
File appeal again against the final order.
My lords, it's the same order, my lords. Your
That
lordship,
doesn't mean, that
I
doesn't
may
mean
be-
that appeal can be sent.
my lords, I may be permitted to read the last line, my lords. In view of the matter, the above petitions are disposed of in terms of the order dated interim order, my lords. 29/11/2024, that is the interim order, your lordship. My
So
lords,
interim-
as there was no pending prayer, my lords,
Interim order has become final order.
29. My lords,
Interim order has become final order.
please, my lords.
But then appeal has to be filed again.
My lords,
That is very obvious.
subject is same, my lords, with regard to additional attempts. No other prayer are pending, my lords. Kindly have it on Wednesday, my lords. Senior will make a mention, my lords. Kindly have it on Wednesday, my lords. Matter is with regard to examination, my lords.
Very.
You read your prayer, it is set aside the common order dated 29/11/2024.
Please, my lords.
Now that order has merged with the final order. So you are required to challenge the final order.
Let's may I request it to be taken in the next week, my lords.
We
I
will
don't-
decide on 16th, at 15th at 2:30.
Please, it's great.
But then don't bring your senior. You will not bring your senior on that. You find out how it is not maintained.
Please.
If you are able to convince us, we will grant stay.
Sixty-six urgent, number 67 to Bairegoda.
Petition number 1 is represented by
What is the
state, Your Lordship.
PL for?
PL for another construction of the building school, Your Lordship. Page number 29, Anashir B1. There's no sanction plan issued by the state. The 7th, 6th, 7th floor, they constructed a building.
Do
I'll
not
take
stop-
steps against the respondent 1.
do not stop
Representative
the-
representative
do not
state, Your Lordship.
advocate for the petition to take steps to serve the
Your
respondent.
Lordship, respondent 1 is to
It shall
take.
be done within 2 weeks.
Your Lordship.
Extend over to 20th February.
Respondent 1 is to state, Your Lordship. I permit to take out notice for you.
Whatever you want to do, you do.
Regarding respondent 4 and 7, I will
From-
take.
From 68 to 74. 3 weeks' time is granted to remove the office objections. Failing which, the writ petition oblique contempt petition oblique writ appeal concerned shall stand automatically dismissed without reference to or order of the court.